Township of Morris Planning Board for October 20th, 2025. The legal notice required in accordance with the Open Public Meetings Act has been satisfied and a statement certifying same will be executed. Could you please rise and join me for the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Could you call the roll?
Yes, Mr. Barrett?
Here.
Ms. Van Order?
Here.
Mr. Flowers?
Here.
Mr. Ravitch?
Here.
Ms. Murphy?
Here.
Mr. Benoit?
Here.
Mr. Quillen?
Here.
Ms. Bariglia?
Here.
Mr. Bye?
Here.
Mr. Warner?
Here.
Ms. Laney? Here. Mr. Bush?
Here.
And I'm Sonia Santiago here.
Okay, our first order of business is a consideration of a resolution. Mr. Warner, you want to tee that up?
Certainly happy to tee it up. Chairman, thank you. Yes, that was the Murray Contracting LLC resolution for three addresses, 7 Three Gables Road, 20 Squirrel Run, and 11 Three Gables Road. That was a preliminary and final subdivision approval in the RA 35 single-family residential zone. 3 lots into 12 lots for residential single-family dwelling, as I recall, purposes. And I believe it was a 9-0 unanimous approval, and numerous conditions of approval associated therewith, as well as a dedication of proposed retention basin and roadway to the township, installation of landscape screening, drainage conditions, just to name a few. And as always, we hope that the resolution was an accurate memorialization of the board's decision. And we will, as always, find out momentarily. And I believe, I'm sure, Sonia has the list of who's qualified to vote on the resolution. Probably all mine, perhaps, or close to them.
Board, any comments on the resolution? Yes, Mr. Quillen?
I have 2 comments. One is pages 4 and 5. On page 4, there's a mention of one of the witnesses for the applicant, Nicholas Rocco. And then on page 5, numbers 11 and 12 refer to Mr. Rocco. I think that's the same person, but I'm not sure.
Absolutely. And what we will do, if I could have a conditional resolution, whichever is the correct name, that will be accurately reflected on pages 4 and 5. We'll have to double check that, as I don't know offhand.
Oh.
And then my other comment, which is more substantive, is about, it's on page 12, item number 10. It's about the proposed topsoil reserve pile. The applicant had originally proposed putting a topsoil reserve pile right next to the current existing house that the property surrounds. And I had not liked that, and they said they would move it. But now I see it just says they'll move the piles further away, subject to review and approval of the township engineer and/or Morris County Soil Conservation District. And I don't remember the Morris County Soil Conservation District having power over this matter.
Ultimately, the county has to provide plan certification for the soil erosion measures, and those stockpiles are not proposed final, but they're temporary in nature for the construction. So it was a discussion over the locations on the property. They'll temporarily stockpile the materials and then redistribute them in final grading. So that is already concurrent jurisdiction to the county.
Can the county overrule you, though?
The applicant has to satisfy me for the board, and then the county gets the second bite at then concurring to the same. It wouldn't work the alternate way.
So I think it should say and instead of and or. Okay, that's all I have.
Mr. Chairman,
Yes.
one small edit, first page, first paragraph.
last sentence, proposed lots 45.01 through 45.02, 45.12. I think.
Yes, thank you.
Can't take credit. Somebody else who can't vote on it noticed it.
And unnamed, thanks to that unnamed person as well.
Mr. Barrett?
Yeah, one additional comment in the same vein, more of a typo. I believe it's on page, looks like it's on page 11. The now therefore language, the second set line should be I believe it should be the 20th day of October, 2025.
Oh, up at the very top?
Yep.
Was that the date we rendered the decision?
Would it be today?
Oh, it should be today's date, isn't it? When we're,
Oh, be it resolved. I'm sorry, that's right. This was originally, thank you, that, it was originally going to be on the meeting of the 6th. That's right. Thank you. And that's right, this got carried. And let me just double check to make sure that, yeah, we changed it elsewhere, but not there. Okay, thank you. I hope that wasn't strike 3. I counted it was. But
Any other
keep on your
comments?
toes.
Then I'll entertain a motion
I'll assume it's as amended.
as amended, right?
So moved.
Second.
Could you call the roll?
Mr. Barrett,
Yes.
Mr. Flowers,
Yes.
Mr. Rabbit,
Yes.
Ms. Murphy. Yes. Mr. Benoit,
Yes.
Mr. Quillen,
Yes.
Mr. Riglia,
Yes.
Mr. Bai.
Yes.
So moved.
Thank you. Okay, moving on to our public hearings. First one on the agenda is PB 0825. Sonia, you want to?
Yes, Mr. Chairman. Application CBO 825, Mark and Lynn Piccolo for minor subdivision with variance. Lot 3501, Lot 6, 35 Schoolhouse Lane in the RA 130 zone. Applicant proposes a minor subdivision to create one additional lot. The applicant will also seek a variance for the lot area.
Mr. Warner?
Yes, Mr. Chairman, I did have an opportunity to review the notice. I did, you may recall, I believe there was an issue with respect to a prior notice, if I'm not mistaken, and some changes were made. It was re-noticed. Bear with me. The content of the notice appears to be sufficient. The timeliness appears to be sufficient. It was certified mailed October 10, published October 10, both at least 10 days prior to this evening. But I do recognize we have objectors counsel. So I suspect the applicant has no issue with the notice. But I don't know if the objectors counsel continues to have an issue with respect to notice or not. We'll find out. But I think the notice is sufficient both in content and timeliness of service and publication. So we could proceed.
Okay. Ms. Lautenfeld?
Thank you, Mr. Chairman. My name is Nancy Lottenville, Lottinv, as in Victor, ILLE, with the firm of Prime, Tuval, and Maselli, Hackensack, New Jersey. Representing Mark and Lynn Piccolo, owners of 25 Schoolhouse Lane, Lot 6, Block 3501. At this time, I would like to query the counsel for the objector as to his opinion of the notice.
Yes, please, yeah.
Sway for high sign.
Members of the board, good evening. Good to be back here. Rob Simon from Herald Law, here on behalf of Mark and Jamie Milano, 40 Schoolhouse Lane, Block 3601, Lot 5. Thank you for recognizing me for purposes of addressing a notice. I have written a number of times to the board now with regard to issues regarding notice and completeness at this point, and I thank council for correcting most of what we perceive to be errors with the initial notice and changes to the plan that were necessitated by those errors. I want to point out two aspects that I think fall under the category of notice and application completeness. Number one is that while the applicant has identified in their notice that 6 variances are required as part of this application, 2 for lot area, 2 for minimum lot width at the required setback, and 2 for minimum required lot width at 40 feet further from the required setback. We also believe that there's a variance or variances that are required pursuant to your zoning table for deficient density, lot density. So for example, in the RA 130 zone where this property is located, there's a under minimum area requirements, and I'm looking at the zoning table directly. It not only has a minimum square footage of 130,680 square feet, which corresponds to a minimum lot size of 3 acres, but there's a separate category. And the separate category is called per family square feet that deals with typically density requirements for a particular zone. So in the Morris Township ordinance for the RA 130 zone, and this also applies actually to all of the residential zones in Morris Township, that there's a separate category called per family. And what that pertains to is the allowed density per lot. And in this case, the per family square footage, not surprisingly, is identical to the minimum lot area requirement of 3 acres. So in this case, that you cannot have more than 1 family per 3 acres. And here, there clearly is a desire to exceed that or intensify that, and that also triggers variance relief for the applicant, essentially for both lots. So you go from 6 variances to now 8 variances. That requirement was not identified in the notice that was provided by publication and to each family, from what I understand, within 200 feet. That's notice. The other point I want to make, and I think it's appropriate to make it now because I made it in my correspondence on not 1 but 2 occasions, is that under both your ordinance and also published case law, that where you're seeking variance relief for, in this case, deficient lot area, density, lot width times 4, that one of the requirements is that you show what the proposed home is going to look like, both in terms of floor plan, both in terms of elevations, so that the board and the public has a full and fair opportunity to weigh the necessary evidence needed to assess whether the applicant meets its burden of proof for, in this case, the 8 variances requested. And in this case, while we know, and we'll get into this later, that there's a house that has already been constructed or about to be finished constructed on one of the lots, the other lot doesn't have a house on it currently. And there's been no elevations, floor plans, designs submitted to the board in support of any variance relief for the lots. And we believe that both under the case law, and I cited to it, as well as under your ordinance itself, because actually your ordinance, even dealing with minor subdivisions, relates back to the certain aspects of the site plan ordinance, which includes the need to show the proposed home on the lot. And as you saw, even from the revised plans, that what is shown are merely conceptual boxes, conceptual septic systems and the like. And so we respectfully contend, in order to preserve the record, that the application should not, again, I referenced this many, many months ago, that the application should not be permitted to proceed until such time as the applicant provides the board and the public with drawings that show the proposed home on the lot, especially given the fact that you're talking about a lot that is seeking a lot area variance where 3 acres are required and approximately 2 acres are proposed. So obviously I'll have a lot more comments and questions throughout, but I just wanted to bring, for the benefit and courtesy of the board, board professionals, those items to the board's attention. Thank you.
Thank you, Mr. Simon.
If I may?
Yes, please.
Thank you, Mr. Chairman. First of all, with reference to density, I am unfamiliar with the schedule that Mr. Simon is referring to, that per family square feet. Okay, thank you. The notice has a savings clause that indicates that any and all variances that may additionally be found to be required are hereby noticed. The notice is extremely detailed and explicit with respect to the fact that it is a 4.125 acre lot that is being requested a minor subdivision for 2 2-acre properties for 2 single-family homes. The subdivision application itself shows and depicts in great clarity 2 single-family homes. I would suggest to you that the per family square feet is incorporated in the request for the lot area variance, and the application itself, as well as the notice, is quite clear. There's absolutely no question in anyone's mind that less than 130,000 square feet would be available per family. So to put a label called density is probably accurate, but not necessary in this situation. Secondly, as of, I believe, July or June or July of this year, the application was deemed complete by the TCC. In Mr. Simon's initial objection letter, which I think was dated August 14th, he asserts that what he has stated this evening, that the application is incomplete because it does not have architectural drawings, floor plans, and other site plan related details on the proposed new lot, which we have depicted in our minor subdivision plan with a footprint of a foundation, driveway, walkways, and additional amenities that all fit within the building envelope. That being said, he is essentially asking for a site plan application when all that is being requested is a minor subdivision. We are not at this point asking for approval of construction on the proposed new lot. And I would bring to the board's attention a most recent ordinance passed in Morris Township, I believe in January, that indicated that 1 and 2 family dwellings do not require site plan review and approval. My client is not a developer. He is not requesting site plan approval of any particular construction on the property of a single family home. He's merely depicting for the purposes of indicating full compliance with side yard, rear yard, front yard, setback, and building envelope that a single-family home can be constructed without additional variances on the property that he's proposing for minor subdivision. Again, I would point out that the board deemed the application complete. And so in my letter of September 18th, I expressed essentially what I've just stated. And I believe that in any and all events, that information is not a matter of completeness. It is not on the checklist for a minor subdivision, and it is really substantive in nature if it's necessary at all.
Mr. Simon?
So I'll take them in turn. First of all, regarding the notice, it's crystal clear, and I think Ms. Lautenville acknowledged it, that the ordinance does have a separate category for density. It's a separate category for a reason. I didn't write the ordinance. It's because it regulates not only lot size, but how many families can be within a certain area in a certain residential zone. And there's different requirements depending on the different residential zones. It's a separate requirement. It has to do with density. It is not at all, as council stated, subsumed, if that was implied, into a lot area variance. There are two separate considerations that need to be assessed by the board and by the public, and that was not noticed by the applicant. With regard to the providing of plans and elevations, I'll take council's argument backwards. First of all, there's no contention that site plan approval, including lighting, landscaping, stormwater management, utilities, and the like, applies to 1 and 2 family homes. That's provided not only in your ordinance, it's also provided in the municipal land use law. That's not at all what we're saying. If the applicant came in with a fully conforming 2-lot minor subdivision with no variances, council would be 100% correct. And frankly, I wouldn't be here. But that's not the case. The case is that the applicant knowingly chose, to make an application for what is now 8 variances. The case law talks about the fact that for a board to properly assess the negative criteria for the granting of variance relief, including whether creating an undersized lot with improper density based on your ordinance, with 2 deviations of lot width are substantially detrimental to the neighborhood and substantially impair the zone plan and zoning ordinance, what does that turn on? It turns on an assessment of what's the property going to look like. And for the board to assess what the property is going to look like, it needs floor plans and elevations. This has nothing to do with site plan approval. It has everything to do with what the case law talks about in terms of assessing the negative criteria. It talks about what is required by your own ordinance in terms of an elevation plan at section 57-110, not to mention that no soil and sediment plan, no utility plan, and no drainage plan was submitted as required by the township's minor subdivision checklist. Now, in terms of what Ms. Lautenville states as to, well, this was deemed complete by the technical review committee, response to that as follows. I serve as board attorney in a number of municipalities. Applications are deemed complete by subcommittees all the time. The whole purpose of providing 200 for public notice, published public notice, is for the public to participate in the application. And that's how a board learns about potential things that were inadvertently missed, part of the public process. And in this case, through no one's fault, that we're raising issues that, not theoretical issues, not philosophical issues, but issues that have a basis strictly set forth in your ordinance, strictly set forth in your checklist, and supported by published, not unpublished, but published case law. So I believe, without taking any notes, that I addressed Ms. Lautenville's comments with regard to whether it's ordinance revisions, completeness, merger, and the like. I'm happy to answer any questions.
Yes, Mr. Warner.
Yeah, I have a question for Mr. Actually, I apologize. Is applicant's counsel through, since we went back and forth and back? We didn't go.
Yes, yeah. Do you have?
I would simply reply to Mr. Simon that the Kaufman case, this is a Kaufman case, deals with the entirety of the evidence. And I find it somewhat disingenuous for him to be saying that floor plans are necessary to judge what the house is going to look like in terms of the neighborhood under the terms and conditions of the Kaufman case. There is no case law that I am aware of that indicates that floor plans would be something that would have to be submitted to a planning board in a Kaufman analysis. In addition to which, there's nothing in the checklist that indicates that any proposed house is required for a minor subdivision. In the realm of possibility, any number of styles of houses could be put on the property, and this municipality does not have a design ordinance. So the situation is, we have a property that can be developed within the requirements of the bulk standards of the ordinance, and the necessity of committing to a particular frontage on a single family house for an unknown owner at an unknown time is just ridiculous. And that is why it's not required. So that's basically, and I rest on the argument that the matter is complete based upon the application and the checklist that was submitted and reviewed, and that's it for now.
Mr. Warner.
Thank you, Mr. Chairman. Mr. Simon, you're not contending that there's a density variant, a D5 density variance?
That's a great segue, Mr. Warner. Thank you for that. So what Mr. Warner is referring to is that under the municipal land use law, under 40:55D-70 D5, that identifies different D variances that are not before the planning board, but are rather before the Board of Adjustment with the supermajority vote, et cetera. And one of those variances is what's called the D5 variance, or a density variance. The reason why, and I thank Steve, I didn't mention anything about specifically a D5 variance is that it doesn't apply here. And the reason why it doesn't apply here is, I'm sure Mr. Warner will agree, is that there's an exception under the D5 Board of Adjustment density variance for 1 and 2 and 2 lot developments. So that when you have a 1 and 2 lot residential development, you are seeking a density deviation for, it does not fall under a D5 density variance. I agree with that.
Thank you for confirming that, Mr. Simon. did you have anything further on to answer the
I
question?
always have a lot further, but you can go on.
Oh my God, we may be similar in that regard,
I know we
perhaps.
are, Mr. Warner.
But and I appreciate you confirm, that is why I asked that question, knowing the answer and appreciating that you confirmed, same. So a D5 would, if there were a D5 at issue, to finish what Mr. Simon was saying, it would require the zoning board of adjustment to hear the case, not us. We would not have that authority. So with confirmation from objectors counsel that it is a bulk variance that objectors counsel is contending is at issue or required, to the extent it may be required under the Pond Run case and its progeny, so long as the notice is sufficient for, and I'm paraphrasing awfully, for the average member of the public to have an understanding of what's at issue in the application, date, time, place, have an opportunity to see the plans, et cetera, to have a general description and sufficient recitation of the variance relief. The applicant can rely on the catch-all language for at least bulk variances, not a D variance, and certainly not one that would absolve this board of jurisdiction and authority to hear the case. And B, it would be sufficient, in my opinion, for a member of the general public with the notice that was provided to decide whether or not they desire to look further into the application, to look at the plans, and to make further inquiry and show up at the hearing. So that's a long-winded way of saying, with all due respect to Mr. Simon's objection to the notice, I still find the content of the notice to be sufficient for purposes of the applicant proceeding with this application, even assuming arguendo that a bulk variance for density is required. So I disagree with Mr. Simon, and I agree with the applicant's counsel on the notice remaining sufficient. As far as the other argument, which is for paraphrasing purposes, methinks the applicant needs to provide architectural plans in order for the board to have what it needs to decide the application, at least, and I believe Mr. Simon, when he says case law, is likely referring to and I apologize to the applicant in this particular case's name. It's either Cicino or Cicino, but versus Township of Berkeley Heights Planning Board, 237 NJ Super 175, an appellate division decision in 1989. While there is some discussion of a potential requirement in that case and by the trial judge, and the trial judge was overruled by the appellate division in that case, at least as to some aspects, I do not believe that, at least at this stage, the board is required, or I should say the applicant is required to provide architectural plans for the board to hear this application. I say that because it is not unusual, i.e., that's a double negative. It's fairly common for minor subdivisions to have concept dwellings provided on the plans for purposes of deciding whether or not the subdivision approval should be granted. And that allows, in essence, the applicant, should they come in with a single-family dwelling on, in this case, proposed lot 6.02, the one that does not yet have a house being constructed on it, so long as they meet all zoning requirements, they can proceed as of right to build that home. If they do not, and they deviate, they may have to come to one of the land use boards, depending upon what those deviations are. So I believe it's sufficient for the board to proceed, and I would agree with applicant's counsel in that regard as well. I think Mr. Simon, on behalf of his clients, objections are reasonable. They're not frivolous, in my opinion, at all, but I disagree with them both. I think the notice is sufficient, and I think the board has what it needs to hear the application. If and when the board decides that, for whatever reason the board decides that you need architectural renderings as the proceedings proceed, that may be a different story, but I don't believe you need them for the applicant to begin presenting the case. And you may decide that you don't need them at all in order to determine whether or not the minor subdivision, along with the lot area, lot width, and possibly density bulk variances, should or should not be granted. So again, to sum up, I would concur with the applicant's counsel on both arguments. And I believe the board can proceed.
Any other comments from our other board professionals?
No, I left out our planner and engineer.
No. Any questions from the board? Okay, I think I'm going to follow the advice of our attorney and allow the application to proceed at this point.
Thank you, Mr. Chairman. At this time, I'd like very much if we could put up the minor subdivision plan.
And if I may, could we just get a list of who your witnesses
Yes.
will be,
Yes, of
and I'll
course.
swear everyone in?
Fine, that would be great. The witnesses will be Mr. Mark Piccolo, the property owner. Here's, are you ready? Kirsten Ostergaard, Osterkorn, I'm sorry. PE, and Alex Doherty.
I'm sorry, can you repeat that?
I'm sorry,
Can you repeat the name?
Alex Doherty,
Sorry.
planner.
Okay. And if all three of you will stand and raise your right hand, and our board professionals will do the same. Do all of you swear to God or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Okay, thank you. Please proceed with
Thank you.
the chair's permission.
Yes, please proceed.
At this time, I would like to mark, for the purposes of the record, the subdivision application plan set prepared by Oscar and Omlin. And I believe it's revised to October 1st, 2025. 3 pages, 3 sheets. And I would then like to call my client, Mr. Mark Piccolo. Mr. Piccolo, would you state your name and address for the record?
Mark Piccolo, 35 Schoolhouse Lane, 35 Schoolhouse Lane, Morris Township, New Jersey.
And you are the owner of the property,
My wife Lynn and I are.
and your wife is also here? Mr.
She is.
Piccolo?
She's seated behind me.
All right. Would you like to give the board the benefit of your ownership and your intentions for the property?
Sure. First, I want to thank everybody for their time here tonight and considering our application. My wife Lynn and I purchased this house almost 2 years ago at this point. We're both from Kinnelon, New Jersey, where my wife spent her entire life, and I lived for almost 25 years. We raised 4 children in Kinnelon. We were both business owners in Kinnelon. Myself, I owned a restaurant for almost 25 years. My wife and her family ran a Montessori preschool for almost 50 years. So we're very much community-minded people. Again, raised our 4 children there. Our 3 oldest are now married with children of their own, and they have relocated to this area. Our oldest daughter bought a house in Morris Township, 1 Knox Hill Road, a beautiful old historic house that they spent maybe way too much money, but a lot of time renovating it. It was a labor of love. And they have 2 of our grandchildren, our 2 grandsons in that house right now that they're raising them. And my son and his wife bought a home in Morris Plains and did quite a bit of renovation on that home. And they're raising 2 more of our grandsons. So we decided to move out this way to be closer to them. We also have another adult daughter who's married with our only granddaughter. She's currently in Hoboken, but she's looking to move out this way as well. So we bought this property because we want to be closer to our kids and our grandkids. And we think we designed a beautiful home that's kind of in keeping with the neighborhood completely as far as style, size. the lot itself was quite a bit more property than we were looking for. We searched a lot on the market for maybe 2 or 3 years to try to find something that met our needs, which the two of us really, single level living, everything all on one floor. So we're not going to be doing a lot of up and down the stairs in our older age. We couldn't find anything, so that's why we decided to build. Neither one of us was looking to build again. And that's where we're at. And we love the neighborhood. Talking about my wife's family being in education for 50 years, we find the schoolhouse so beautiful. Joined the organization literally once we became property owners. And as I said, it's a big piece of property. It's way too much for us to maintain. And we're just trying to do a subdivision, separating the house that we've built now from it and having a separate lot for no planned purpose at this point.
Can you tell the board what the property was improved with at the time you purchased it?
When I purchased it, it was a single family home. We loved it. It had a lot of character. It had a slate roof. But it had a lot of things. It didn't lend itself to single floor living, which is what we were looking for. We also felt that the garages facing Schoolhouse Lane wasn't a desirable footprint for a house, and the front door was actually facing what I later learned was a private driveway that runs off of Schoolhouse Lane that feeds a couple of lots up on top. But it was similar size house and square footage and all to what we ultimately are building right now. So we felt that what we designed, again, kept kind of the same character of the property and the neighborhood.
And the size of the house that you're building now is how many bedrooms, square feet, et cetera?
4 bedrooms, 3,800 square feet, I think is where it's at.
And I understand you're also going to put in a pool?
The pool is in already.
There previously was a pool?
There was a pool, probably a larger pool with a waterfall and things of that nature. Again, I probably didn't think I would have another pool, but now that we're on 4 and a soon-to-be 5th grandchild arriving in New Year's, we made a few changes for the sake of the grandchildren.
And I think you indicated to me when we first put the application together, the plan set together, that you might like to make some changes with respect to the proposed lot 602 with respect to the driveway. Is that correct?
If we're granted a new approval lot, yeah, we would like that lot to probably have its own access. And the driveway that we're currently using on the current house is the existing driveway, so we haven't changed anything in that regard.
The new driveway, I was referring to the location of the new driveway. You might want to put it on the opposite side of the conceptual house.
Other than what's shown on.
The second, the third sheet of the exhibit 1.
Thank you.
So this is sheet 2. Could we advance one more sheet, please? You wanted to move the driveway. Okay.
I don't really have an opinion on the driveway of the proposed second lot. Obviously, from what our professionals advised was that we put a footprint of a similar sized house to just show that a similar sized house could be constructed on the lot without requiring any other variances as far as setbacks or anything of that nature. But the actual, direction of the driveway coming off Schoolhouse Lane, I don't have an opinion on it one way or the other. I haven't thought that far down the road.
All right. And as the seller of the property, you would be able to influence to some extent the construction of the house?
Yes.
On the new lot?
I would hope so, because it would obviously be our closest neighbor. And again, we don't have any desire to do it. Maybe one of our children will want to build a house on there. Maybe it will be one of my wife's lifelong friends who might want to build a house there, but we don't have any plans for it. but obviously we'd love to have another neighbor so close by, similar to ours.
That's all I have at this time.
Any questions from our board professionals? Oh, yeah, I.
Pleasure of the chair.
I don't.
No, okay.
Not here.
Any questions from the board?
I guess I'll ask a
Yeah,
question.
go ahead.
So when you bought the property, you knew it was less than 6 acres, right?
Correct.
So
Well-
you knew that to subdivide it would require a variance, which you might or might not get. I don't know if you were thinking about subdividing it at that time.
I wasn't actually, and honestly didn't even know what the building lot code was at 3 acres. Honestly, we bought it. And again, loved the character of the house that was there. I mean, some things that we've never had in other houses that we've owned. Again, a slate roof, a beautiful fireplace. I actually brought in professionals to take a look at it to see if we couldn't just renovate the existing space to make it what clearly we wanted again, which was 1 floor living, and put, I don't know, we might have put 6 months to a year just in exploring that option. So subdivision never was even on our radar when we bought the house, and I would say easily a year into owning it. Then when we decided that we couldn't, and everybody told us we'll spend more money trying to renovate that into what we ultimately need, we're better off knocking it down and building a new house. Well, then, and where is it going to be situated? Now it's actually the front door is going to face Schoolhouse Lane, which I think is a lot more appropriate for the neighborhood and for our needs. Then it became, okay, now I have this huge extra, whatever you want to call it, side yard that I did pay to mow for the last year, just to keep it obviously neat and not unsightly, and certainly don't have any desire to have that much land later on.
The previous house I think the previous house straddled your proposed lot dividing line. Is that true, or was it very close
No,
to it?
actually,
No?
because I think actually I'll tell you what I think did straddle was the old pool.
Oh, I see.
I think the house itself is almost exactly in the same footprint, but the pool was set to the right of the house, where our pool now is straight in line with the house, so it goes straight back.
And the size of your lot, I seem to recall from the last time we were here that the lot size was described as 4.5 acres, but now it's being described as something smaller. Does that have to do with, maybe a question for your counsel, does that have to do with the right of way for the
Yes,
street?
it does. The situation was that, and I've given a full documentation to your counsel as well as objectors' counsel. The right-of-way was never dedicated along Schoolhouse Lane for this property or for possibly others. We did quite a bit of research into the title. The property was originally subdivided in 1960. And the lot was created at that time, Lot 6, subject property,
What date?
1960.
Okay.
At that point, there was no dedication. It was a subdivision done before the well before the MLUL, and without a plat. It was done by deed. The road existed obviously at the time, and the 4 subsequent conveyances used the exact same description as in the original subdivision deed. And so there were apparently no one bothered to do a survey, an updated survey. So we were somewhat caught by surprise to realize that the dedication had not occurred. And we then did a good deal of research, which I laid out for Mr. Warner and Mr. Simon, with respect to the fact that the right-of-way is a 50-foot right-of-way pursuant to typical minor street in Morris Township. And we calculated all of the deed descriptions came from the center line, but the center line was never identified by width at all. So we went on both sides, behind, to the side and up the road, and we did locate 1989 dedication of Schoolhouse Lane, or I believe it is lot.
Are we seeing the,
There was a dedication further up the street for a 25-foot half width, and it matches the tax map, which indicates a 50-foot right-of-way. So we have now shown on the plan,
I think, are we looking at?
That's not the
I think
correct
we're looking
plan.
at the original set.
That's not the
This one
revised
doesn't
plan?
show the right of way.
It doesn't have the 10-1 date on it.
All right. These are the plans from last
Right,
month,
this doesn't
last
show
month,
the,
2 months ago.
right.
We need to show, oh gosh, do we have a hard copy? We should have it.
No, I mean, I have, no, my hard copies are correct. I just realized, like, I was looking at it, I don't change it.
All right. This is the prior plan.
This is the prior plan. Right.
All right, while we're having an adjustment, that is the prior plan.
Right.
All right. The new plan shows a 25-foot shadowed area that indicates the right-of-way, and that subtracted 15,247 square feet, which reduced the acreage from 4.5 to 4.125. The reduction of the acreage by the 15,247 square foot right-of-way reduced the acreage from 4.5 to 4.159. That's the right plan? All right, let's move to the second page. And then the third page. Okay, that's the correct,
Yeah.
and our engineer will testify to this. So by way of explanation, that is why the lot size changed. The full lot size, the two proposed subdivided lots changed because we've now subtracted the right-of-way area to show a 25-foot half width for Schoolhouse Lane, which we're willing, of course, to dedicate to the township.
Okay, thank you.
Thank
That's
you.
all I had.
All right, I think if there are no further questions for Mr. Piccolo.
Any other questions from the
Unless
board?
Mr. Simon?
Yeah, I just want to, there's no more questions from the board? Mr. Simon?
Mr. Chairman, I have one question.
Oh, can you hold on a second? Yes.
I'm looking at 3 of 3 on those set that was most recently sent to us.
Yes.
And it indicates here that the, it says, the lot, existing lot 6 was 4.15, which was the one before the easement was applied. But when you looked at the proposed 6.01 and 6.02, if you add those two up, it's 4.159. Is that correct?
That's what she said, yeah.
So it wasn't easy to decipher that, but the ones, I was originally thinking we got the old plan again, but we didn't.
Oh, I think that, yeah. Okay. Mr. Simon? You have a question? I mean, or do
I
you?
have questions, but this gentleman came up.
Mr. Chairman, would you prefer to?
I would
have
prefer that,
objectors'
Mr. Simon,
counsel
you go
first?
first, and then the public can ask, will get a chance to ask questions.
Sure, happy to.
Just to be clear, all members of the public will have an opportunity to ask questions of each witness as well as ultimately make public comment. But as is not uncommon, there's that double negative again. As is common, the chair is having the represented objectors' counsel ask questions first.
And I
Thank
would note
It's at
that,
discretion of the chair.
yes, and I would note that the members of the public represented by Mr. Simon are not allowed to ask questions. They make comments later, but but not questions of the witnesses during the proceedings.
Yeah, I've instructed my clients accordingly.
I'm sure you have. I
Yes,
just
but
want
thank
to
you.
make sure that everyone else knows that.
Of course,
those are the
appreciate that.
guidelines.
Thank you.
So, thank you.
Yes, yes. Mr. Piccolo, good evening. Just a bunch of questions in no particular order. Do any of the plans, sheets 1, 2, or 3, show existing conditions in terms of where the house used to be located on the property?
I don't, they're not noted on the plans.
And if I was to tell you, because I have reviewed aerials of your application and your property, first of all, there's a building that's currently located on lot 6.02. You're familiar with that?
Yes, I am.
Okay, what is that building?
It's a detached garage from the previous built home.
Is there a reason why that detached garage from the previous home remains on the property right now without a single-family home on it for lot 6.02?
It's not a reason, well, it's currently holding all of my wife's and my possessions from the home that we moved out of in Kinnelon. And we're living in an apartment in Morristown right now. So it's holding all of our possessions that'll get moved into the new house when we,
Okay, once you get a CO and move into the new house, do you intend to use the detached garage that's currently on the property as an accessory building structure for the existing home?
I do not.
So is your intention to what is your intention with regard to that garage?
I have not given it any thought. At this point in our construction, I'm not looking to spend any more money actually right now. So I have no desires to do anything with it unless it needs to come down.
So it's going to be, until further notice, it's going to be used for storage, but not to house any vehicles.
No, it won't be used for anything once we move into the new house.
Meaning it won't be used for storage either?
It will not be used for storage either.
Okay. And with regard to, you testified on direct about a pool that previously existed on the property. Am I correct to state that that pool was located on what is now proposed on sheet 3 of 3 as lot 6.02?
I don't believe so. I mean, if you have something that shows that it was, but I literally was probably looking at the spot where that pool used to be this afternoon, and I believe it's in my opinion, it's all completely on 6.01.
So your sworn testimony is that none of the prior pool was located on lot 6.02?
Mr. Chairman, this is not this is testimony that's better directed to our engineer, whose firm also prepared the site plan as well as did the original survey work. I think if we're going to be talking about location of previous structures that no longer exist, I think that would be questions more well answered through the engineer.
The reason why I'm asking the questions of this particular witness is that this particular witness testified to those facts on direct. That's why I'm questioning him on cross. He talked about the fact that none of the improvements that were formerly on this property were located on what is now proposed to be lot 6.02. If that's his testimony, that's his testimony, and we can move on from that. So you've never lived at the property, right, Mr. Piccolo?
Correct.
And when you purchased this property 2 years ago, before you closed, you did an inspection of the house, correct?
It's my remembrance, yes.
And the issues that you raise about the house at the time not being a single-story house, was that of concern to you prior to you purchasing this property?
No,
And why not?
because I assumed that we could make that property into what we ultimately hoped for.
When you say what you ultimately hoped for, was your intention to demolish the home that was currently on the property when you purchased it?
No,
Okay, so prior to purchasing the home, did you communicate with any architect or builder about the ability to renovate the then existing home to make it a single-story home that you desired?
not that I can remember.
And how long had you owned this property before you first contracted with a architect to design the property that's been built?
I don't remember.
And who determined where the house that has now been constructed on this property would be sited on the property?
I'm guessing that it was the professionals that we hired.
You're guessing. Did you participate in a determination of where on the property the house that was built would be sited?
I'm sure my wife and I ultimately made all the decisions.
Do you recall specifically deciding to put the house to the left of where the then existing house was located?
My wife and I ultimately made the decision as to where that house is currently built. And we have the ultimate decision. So I'm going to say yes, we made the ultimate decision.
When you submitted plans, or your contractor submitted plans for building permits to construct this house, was it contemplated that there would be a subdivision of this property?
No,
And what makes you determine that?
it's just how my recollection.
Okay, so at what point did you determine that you were going to seek a subdivision of this property?
I don't remember specifically.
Was it during construction of this home on this property, sir?
Considering that we're still under construction of that home, then I think obviously we made a decision at some point during the construction because the house is still under construction.
And you stated in your direct that it came a point where you determined that the property was quote unquote too big of a property to maintain. When did you make that determination, sir?
I'm going to guess sometime along the way where I was paying a landscaper to cut the grass every week. It may also be that the previous owner had a very large tractor with a pull-behind mower that was in that separated garage along with a regular John Deere. And I probably naively thought they were going to leave those there. They didn't, so that did it. Then I started to hire somebody to cut the grass on a weekly basis. And
So you didn't make any arrangements to have the grass cutting equipment, mowers, et cetera, be included in the sale of the property?
no, I did not.
Mm-hmm. And at what did you determine prior to purchasing? Well, strike that. Do you recall how much money was being charged to you to cut the grass?
I do not.
And prior to purchasing the property, you did no due diligence to determine the zoning standards applicable to the zone within which this property is located.
I did not.
And when you say the pool size is the same, are you talking about the pool that is depicted on sheet 3 of 3 in the back of the property?
I don't remember saying that I thought the pool was the same size. What I remember saying was that the orientation of the pool is completely different. Yes, it's behind the house now where it was on the side of the house before.
So is the pool size bigger or smaller now versus what previously existed?
I don't have any of the measurements, but my guess would be that it's significantly smaller because, again, we put it in specifically because we're soon to have 5 grandchildren, and because my wife's family ran preschools for 50 years. We kept it only 3 feet deep in the low end, and I don't think it goes above 5 or 6 feet in the deep end. So it was specifically designed to be a small pool to accommodate our grandchildren.
And when did you remove the pool that existed when you purchased the property? How soon after you purchased the property?
I believe it was removed, decommissioned, or whatever it is that they do with it during the demolition of the house.
And do you remember when that demolition took place?
I do not.
And do you remember why it was that the architect concluded that it wasn't, I think you said feasible, but that's what I wrote down, to renovate the house as opposed to construct a new house?
I'm sorry, the question is, when did I decide it was feasible?
If you're taking notes for him,
No, I'm not.
that's not appropriate.
I'm not taking notes for him.
You wrote a note and you referenced to him. I want to ask questions. I just want honest answers.
I would like relevance.
Wait, Mr. Chairman?
Yes.
Yeah, whether or not that just occurred, I don't think applicant's counsel's response for relevance is appropriate. So I'll let the board observe whatever the board observed, but I think Mr. Simon can continue the questions, and I respectfully request the chair perhaps suggest to applicant's counsel that the board will determine whether or not questions are relevant. If she has an objection, she can make an objection.
Thank you, Mr. Warner. Please continue, Mr. Simon.
I'll repeat the question. I apologize for the delay. What led your architect to conclude, or what led you to conclude, that it was better to engage in demolition and build a new house as opposed to renovating the then existing house?
Because professionals recommended it.
Okay. Do you remember why the professionals recommended it?
I do not remember specifically.
And you stated that what you constructed here was a similarly sized home. Do you know what the approximate square footage is of the home that you built here?
I believe the plans and permit call for 3,800 square feet.
And do you remember what the square footage of the house was that you demolished?
I do not.
Did you explore with the architect? By the way, what architect did you use to assess whether the first house could be renovated? Do you remember?
I do not remember their names specifically.
And you talked about the front door now facing Schoolhouse Lane. Did you discuss with the architect or?
Can I ask, I will ask a question about relevance here. I mean, we are presented with the plans that have existing conditions. These are the existing conditions, except as you noted, there may be a building on it that's not shown. So I'm questioning on, the relevance of asking the details of this house, which has been permitted and approved for construction. And it, as shown on the, existing conditions drawing.
Well, the details as a proffer is that this house was specifically constructed on the left side of this property, and permits were obtained to build a house, a new house, on the left side of this property, which is contrary to, with all due respect, to the applicant, to what the applicant testified. And I've asked what I respectfully believe are relevant questions based on the direct examination answers that were provided by this witness. And I've gotten a lot of, I don't remember, I don't recall. And so the only two more questions. One of them is whether Mr. Piccolo, you referenced in your direct examination that now the front door to the new house faces Schoolhouse Lane. So my question is, did you discuss with your architect prior to demolishing the prior house whether the house could be renovated so that the front door would face Schoolhouse Lane? If you recall.
I would say that we did.
And what was the reason why the house could not be renovated so that the front door would face Schoolhouse Lane?
I would be totally speculating, but the fact of the matter is that the old house had garages that were underneath the house. So in order to put a front door where the garages were, I think engineering wise, architecturally wise, didn't make any sense. And that's just my recollection.
Okay, and again, you don't remember which architect you spoke with, correct?
I did not.
Was it the architect that designed the new house?
No.
Just give me a minute. I may not have enough questions. When you purchased this house, do you recall doing any due diligence to determine whether the subject neighborhood is located in a historic district?
No.
All right, nothing further. Thank you.
Any other questions from the public for this witness? Okay, please, you can go up to the stand and state your name and address if you have any questions.
Hi, my name is Richard Smith.
Could you speak a little closer to the microphone?
Sure.
Raise it up a little bit. Thank you.
It's Richard Smith, 44 Schoolhouse, right across the street. There was, when I look at the maps, there was discussion of how wide the road is. The road was established as a 66-foot road in the late 1700s.
So, this is the time to ask Mr. Piccolo questions based on his testimony.
Oh, okay. All right.
Do you have any questions of him, or did you want to make a statement?
No, I have no question.
Okay, that period will come later with the chair's permission, public comment period.
Yes. Okay. No more questions from the public? Okay. Ms. Lawton,
A quick, if I might redirect.
okay. Yes. Yes. you're
Mr.
right.
Piccolo, are you maintaining the same curb cut driveway entrance from the house that you bought to the house that you're building?
Yes.
And is the location of the driveway in part the reason why you placed your new house in the same area as the old house?
Yes.
And by placing, no further questions.
Yes, Mr. Simon.
Mr. Piccolo, the location of the driveway off of Schoolhouse Lane is exactly the same as at the time when it was servicing the house that was on the lot when you purchased it, correct?
Correct.
And the difference, or if you recall, and I'm referring to sheet 3 of 3 on the applicant's plan, Nancy, last dated October 1st? October 1st, 2025. The difference is that the driveway came from its current location, came kind of straight up, correct?
No,
No?
no,
And didn't go into a
No.
turnaround?
no. Went into a turnaround where my front current garages are. That was the orientation of the old house. That's where the front door was. They had a turnaround that went right around circular to the left side of the house. That's where the front door was.
Right, so the house that was on the property was partially located to the right or to the east of the house that's currently located on the property, correct?
I don't know where the location of the old house was, but I'm telling you that the driveway had the same cut from the road, went up. Part of the driveway went into the garages that are straight ahead where my front door is now. And then the driveway also continued up to the left, did a turnaround where the front door was. That was the existing driveway.
And is there a reason why, talking about the driveway, why the house wasn't designed whereby the garages weren't on the east side of the property as opposed to the west side of the property?
That's just where the architect and the engineers designed it. And if it saved me money not relocating the entire driveway, I was absolutely all for it.
Nothing further, thank you.
Next witness?
If we could
Unless-
have a short break, I want to verify we have the right exhibits. Just a 5-minute break, and I will call my next witness, which
Ms.
would be the
Longo.
engineer.
Okay, yes, we'll,
Thank you.
short 5-minute break. On, please. So we need to call roll again? Or are we all fine? I think we're all here, right? Okay. I would like to announce that we have several other items for business that we have to get to tonight. So I am going to try hard to cut off the testimony and this hearing at 9:30. And we may have to carry it, but we have business after this that will take probably about a half an hour that we'd like to conclude. So we will have a fairly hard stop at 9:30. We'll finish any questions that are, going on at 9:30, but we will entertain no more testimony or questions after 9:30. So, thank you. Ms. Lautenville, you want to-
Thank you, Mr. Chairman. At this time, I would like to call Kirsten Osterkorn, who is who prepared the subdivision plan. Ms. Osterkorn, you've previously been sworn,
Yes.
and would you state your name, address for the record, please?
Kirsten Osterkorn, Osterkorn, 42 Central Ave, Midland Park, New Jersey, from Omland and Osterkorn.
Thank you. And you prepared the minor subdivision plan that is exhibited here, revised to October 1, 2025. Is that
Yes.
correct?
Yep.
Would you like to please
I'm sorry, you're a,
Yes.
Sorry.
Qualifications.
you're an engineer licensed in the state of New
Yes, thank
Jersey?
Yes.
And your license remains in good standing?
Yes, I'm going to
You
be,
testify as an expert before various land use boards in the state of New Jersey and been accepted as an expert in the field of civil engineering before same
and land surveying.
and land
We're
surveying.
gonna talk-
And you're seeking to be, by applicant's counsel, you're seeking to be accepted as an expert in both fields?
Yes.
Land surveying and engineering?
Yes.
Mr. Simon, any objection to Ms. Osterkorn being accepted as an expert by this board in both practice areas?
Not in terms of being qualified to provide testimony as an engineer licensed.
Okay, that's all I was asking at this point. So over to the chairman.
Okay, thank you. You may proceed. We'll accept your qualifications. Go
Sorry,
ahead.
we just rolled right into it. Okay. Can we go to sheet 2, please? I'm used to having a board in front of me. Okay. So the current property, lot 3501, lot 6, is 35 Schoolhouse Lane.
By the way, this is sheet 2 of Exhibit A1, right?
Yes,
Okay,
sorry.
and that's the site plan that was, subdivision plan, excuse me, October 1 last revised, correct?
Yes.
Okay, thank you.
For the purposes of when I talk, I'm gonna, north is to the top of the page, south is at Schoolhouse Lane. Under existing conditions, from the time that the survey was done for the deed that was provided from the research that we had, the lot was 4.51 acres, 196,436 feet. We had found evidence that showed on both sides of the property, iron pipes, control in the back for iron pipes along Schoolhouse Lane that showed there was right-of-way dedications done at some point, but at this time for this property, from the title that was provided to us after the purchase, there was no dedication that was done for the property at that time. Under existing conditions, the property slopes to Schoolhouse Lane from the rear left corner to the rear right corner, as you can see from the dashed lines, the existing general contours that are there. At the time of the survey, we were brought in after Mr. Piccolo had bought the property. Pursuant to the start of the construction of the house, you can see at the time of the survey of where we have the existing drive going in and where the placement of the house that was under construction lies. I noted under, which is hard to see on these plans, but I tried to put it in big under the permit numbers that were for the house under construction. If we can, I did note, and I do apologize because it was noted that the shed got left off. I had it on there, and for some reason it just was there's a CAD layer control issue. But when we were out there, that shed was there. That's up in this corner over here.
I'm sorry, up in this.
No, I'm sorry, the northeast corner of the property.
I was to say, speak directionally, thank you.
I know, sorry about that. Northeast corner. If we go to sheet 3, please. Magic. Under proposed conditions, we're proposing lot 6.01 and 6.02. We can see on the property that the property in general originally is kind of like a parallelogram. It's not at right angles to Schoolhouse Lane. It bends off to the left to the northwest. Under proposed conditions, we are noting the area of the 25-foot deeded dedication that would go to the town that corresponds with the 50-foot right-of-way that lines up with work that was done on both sides of the property as well, based on the evidence that we did find in the field. So under proposed conditions, the way we established the proposed subdivision line was to ensure that the lot width at Schoolhouse Lane complied with the 300-foot lot width requirement. Lot 6.02 is, where are my numbers? Sorry, 302.4 feet, and lot 6.01 is 302.4 and 6.02 is 301 feet in lot width at the right of way. The variances that were mentioned previously was at the setback line and then at 40 feet past the setback line. And those were some of the variances that the planner will be testifying to later. Under these conditions, we show more to the proposed dwelling that was under construction and working the driveway. The placement of the house, as noted previously, was the front door was to the southwest side of the dwelling, which then it was speaking to of the pool and other features that were at the rear of the dwelling, which is more on the north side of the page. Under proposed conditions with the construction of the house, we have the front door facing Schoolhouse Lane with a side entry garage. Before it was a front entry garage, so we maintained the existing curb cut in Schoolhouse Lane, and we sweep the driveway over slightly in order to have a nice side entry garage. With the grading conditions of the property, the way we set the elevations of the house, working off of the top of foundation that we had to work with, we were able to design a pool centered off the back of the house. We cut into the northwest side a little bit in the slope, and on the southeast side of the house, we're doing a little bit of fill. We were able to then show the drainage system and the septic that all were part of the construction documents that fell under the building permit. So everything that's shown on lot 6.01 matches to the building permit package that permitted the applicant to be building the single family dwelling. As part of the subdivision, then on the right side of the property, on the northeast side, we took a similar size structure. We kept it as a box. We didn't have as many details for porch and covered patios or anything out in the backyard, and did a same sweeping type of driveway entrance to the left for a side entry garage. I know it was mentioned about the potential of flipping the driveway to the right side. Ultimately, a building permit and lot grading permit for the engineer to review would have to be designed and approved. At this point, looking at the grading of the lot, if we go to the right side, you're probably more looking at a garage under type of situation. I still think the left side makes sense. It keeps the septic systems separate. Both properties have well water. So everything would have been looked at to make sure everything's within proximity of the neighboring properties and that the septics can comply with requirements from the health department on that side. I know it was spoken to of looking to see some sort of renderings or diagrams of the building. It was looked at as just being a basic two-family, a simple size that complies with all bulk requirements. While we have the variances for lot area and lot width at the setback lines, and then what was brought into was the density aspect of 1 single family per 3 acres, the rest of the bulk requirements are not being exacerbated. The size of the building that is there would comply with all required front yard setback, rear yard requirements. Coverages for both building coverage and impervious coverage would all comply with. If approved for the subdivision, when that lot 6.02 is built upon and a building permit would be submitted to the town, it would be the conditions of complying with those bulk requirements. If someone were to seek later any other type of variance being requested, they'd be back in front. But the intent is that everything does comply and fit and match of 2 similar size properties, 2 similar developed looking properties. We were looking to keep the existing landscaping that's along Schoolhouse Lane, aside from introducing the 1 curb cut for lot 6.02. All of the existing trees that create a buffer on both the east and north and west side is a tree road to all the surrounding properties. From being out there and still being down at Schoolhouse Lane of how the property does slope up, it's not an overbuilt in that sense, and the planner will be able to speak more to that, of building 2 what I would view as decent sized homes that fit the lots in terms of all of the bulk requirements that are being requested. We do understand that we have the variances for the lot area and lot widths, but at the end of the day, the houses are in proportion to the lot sizes being proposed. With respect to utilities, drainage would be provided on both properties that meets the requirements to septic and well. There would be septic and well for each property as well. Then I think that's it, as I'm looking at the plan. Do you have specifics?
I have a couple of questions. Did you have an opportunity to calculate the combined building coverage of lot 601
Yes.
and proposed lot 602?
So the building coverage separately for each lot. So 6.01 is 4.4%, where 10% is permitted. So it's 3,833 square feet. Total impervious coverage is at 15.8%, where 25% is permitted. So the proposed impervious for 6.01 is 13,771. It's outlined in the chart on the plan as well. For lot 6.02, we proposed a building coverage of 3,400, so that's 3.4%, where 10% is permitted. And our proposed impervious coverage is 10,018 square feet, which is 10%, where 25. When we look at the lot as if it was all together for the coverages, the combined is 7,233 square feet for building coverage, where 13,680 is permitted. So for the lots together, even if you were to look at all the coverages, the size of a building that could be, the 2 separately still comply with the building coverage. And similarly for impervious coverage, the proposed together is 23,789 square feet, where 32,670 is permitted on the lots together. So from a percentage type of speaking, both lots are approximately half of what's permitted on the 3-acre lot from building coverage. And for impervious, they're about 2/3 of what's permitted for those the lots that are permitted in the zone. So, which the planner will be able to speak to more of the size and appropriateness of the impervious coverage and building coverage on the lots.
So you testified that the lot frontage for proposed lot 601 and 602 each exceed 300 feet, is that correct? At Schoolhouse Lane?
Yes, at the dedicated 25-foot wide right-of-way lane, they are both over 300 linear feet.
And that is the requirement for a 3-acre lot, is
Yes.
that correct? And with respect to the front yard setback, the interior lot width, both in two spots, the front setback and the 40 feet beyond the front setback. First, would you indicate where those lines are on the plan? And
Sure. I'll make sure I say this good. So on the southeast side of the page, the bottom of the page, is the Schoolhouse Lane right-of-way. Just north of that, at the setback line, there is a line that goes across from west to east. And then another 40 feet beyond that is another line that goes from west to east to give those dimensions that are on the plan.
And both of those interior lot width lines are, with respect to lot 601, the house is behind both of those lines, is that correct?
Yes.
And the widths of those two lines are interior lot widths.
Where are my numbers? Sorry. Last page, sorry. Okay. For lot 6.01, at the front yard setback is 287.1 feet, where the 300 foot's required, and 40 feet beyond that is 281 feet. For lot 6.02, at the front yard setback line is 270 feet, and 40 feet beyond that is 257.6.
And the requirement for a lot width for a 3-acre lot is
300.
300 feet. So each of those two lines on those two lots is slightly short of the required 300 feet.
Yes.
And what is the overall shape of the lot?
Parallelogram.
A parallelogram or a trapezoid?
Trapezoid, parallel.
It's been a while since.
Oh, my geometry class. They are not it's not a rectangle, perfect 90-degree shaped lot. So as the line gets set back further and meeting, it was getting smaller as you go back. The rear side of the property to the north is less in width than the front of the property, but we do meet the lot depth requirements, which gave us our lot areas.
Actually, is the lot depth even higher than?
Yes.
Required?
Yeah.
And that's by how much? A 3-acre lot requires a lot depth of what?
No, numbers here, hold on. Wait. Sorry. We have lot depth is supposed to be 300 feet, and we have an average lot depth. The existing lot's 423 feet. Lot 6.01 is 351 feet, and 6.02 is 486 feet. So over the 300-foot lot depth requirement.
Okay, thank you. I think that would be, are you?
I'm good. It was all technical fun stuff.
Yes, all right, so that's all my questions.
Any questions from the board? Yes.
I'm not sure if this is the right witness to ask this out, but I'd like to refer to page 1 of the package that was sent to us.
Sheet 1?
Yeah.
And specifically the zoning map. I think you can enlarge on specifically the zoning map, which is at the bottom of the page. Can you comment on the neighboring lots that front Schoolhouse Lane that are adjacent to this subject property?
Is this a question that we'd better direct into the planner?
I don't
You have
know.
a planner
I don't know.
coming
I
up.
said I didn't.
We do have a plan. Probably not tonight, though, because we're going to get cut off. But is there more to I don't know didn't finish the question. You just,
No, that was my question. There are several properties along Schoolhouse Lane
yeah.
that are of interest to me. I was hoping someone could comment on them relative to this subject property.
I think that is more the planner, I'm sorry.
Hold that question.
Any other questions from the board?
Just
Yeah,
one quick
Mr.
question.
Rabbits.
Thank you for your testimony. You mentioned being brought into this project. When were you brought into this project?
After the applicant had bought the property, they had bought it, from my understanding, without a survey, so I came in initially to do the survey, actually by the attorney.
So you were brought in to work on the home that's being built currently? Or were you brought in to work on the subdivision?
The subdivision wasn't a conversation when I was first brought in. It was, can you do a survey of our property, was the beginning parts of everything.
Okay, and how soon after that were you asked to work on the subdivision?
Hold on. So it's 20, these dated probably a year. Because my survey was March of 2024 was my initial survey, and then we came back later that year after. But the subdivision, I don't know the exact dates, but it was later after the survey portion happened first.
Okay, so how long have you been working on this particular part of the project, the subdivision?
So I would say since March.
Of this year?
Yeah.
Thank you.
So you were brought on to do survey of the existing property. Was that in order to get the permits for the construction of the new one?
Yes.
Okay. That's. Any other questions? Board professionals?
Okay. Just to tie a bow on it, it's trapezoid, not a parallelogram, because
Thank you.
because they're not parallel to each other. Angles,
right?
And as proposed,
Can you tie a bow on a trapeze?
you have to do it on the short top side. It's the proper place to put it. So, bit of confirmation on your testimony. The outbound survey is under your PLS, originally from April 2024, and then revised through with the plan date.
Yes. Yep.
And so then for Recordation Act, then you're the proposing surveyor of the subdivision on the same boundary, correct?
Yes.
There's evidence found in the front pins on the west and east side of the property. Are those coincident to the proposed right-of-way dedication, or is there an offset to that proposed dedication?
No, they lined up with the 25 feet. When we did the survey in March, April of 2024, I was only provided the deed at the time, which is why it went to the center line of road.
Okay.
And then subsequent from the conversations we had in the past couple months, we requested title searches of neighboring properties on the subject property, which led to our proposed dedication.
So in that additional effort, the property was field located to that evidence. So you're confident on the boundary as proposed, as shown?
Yes. I mean, even when we did it last year, I was confident where it was. We showed all the evidence we found. We just had called the deed to the center line of road because that was the only documentation we were provided at the time of the survey.
And so there's a third pin in the northwest corner
Yes.
of the existing property. From those three pins that I've referenced, you find it appropriate to be able to field locate any proposed subdivision that's approved without additional monumentation?
Yes.
You were the engineer of record for the block grading approval as well on the existing dwelling?
Yes.
So you have accurate files as to the proposed disturbances and then for the as-built of what would be disturbance on the lot for that construction?
Yes.
Would you agree that with the proposed subdivision after February of 2004, all future improvements to the parent lot, so proposed 601 and 602, would be summarily against the major development standards for lot disturbance and impervious coverage?
Can you repeat that again?
So
Sorry.
since the subdivision is to a lot created prior to 2004, the creation of the stormwater rules
Yes.
and Jack 7-8, that the total cumulative disturbance of both lots would be these, the triggering points for a major development standard on future development of this parcel. So in other words, when lot 6.02 is constructed, it will have the balance of the 1 acre threshold already disturbed for the existing dwelling, and then the balance of the 1/4 acre threshold from what is 13,771 on proposed lot 601 minus the 8,720 of the prior existing conditions.
I believe, but I don't also have the numbers exactly. I'd have to, understanding we're coming back, I'd pull up the lot grading, all those numbers along with the proposed for the sub, but I don't want to speak to numbers.
So I'm confident that the original lot grading was a minor development on the existing parent lot.
Yes.
And there will be a threshold cumulatively for future development of lot 6.02 that will take into consideration the improvements on the lot as it exists today, as the dwelling under construction.
To not trigger a major development.
To not trigger a
Yes.
major development?
That would be the,
What many of us call a creeping major development?
yes, yes.
Okay. And you're comfortable with that for any proposed plans at a future date on lot 6.02?
Yes, there would be I try very hard with my clients never to trigger major development because I don't want to do those.
Okay.
So I know we had looked at the numbers. I just don't want to speak to hard numbers.
No, but yeah, you agree it's a minor development as constructed through the permits
Yes.
today, and that the thresholds will be cumulatively
Less than an acre, less than a 1/4 acre increase.
Thank you.
Yes.
And the existing driveway for the orientation of the existing home utilized what appears to be maybe the first 30% or so of the existing alignment to maintain the site triangle through the existing street trees.
Yes. Can you go to show sheet 2? I don't know who's listening to me when I ask that question. Yeah, we can see on the page where on the schoolhouse where the curb cut is, and how it does have more of a straight entry to where the circular drive is versus if we go to sheet 2, it starts to curve to the left more for the side entry garage of where you can see that located. But I would say, as the engineer had noted, 2/3 of it coming up, 50% to 2/3. Coming up from schoolhouse are maintaining the existing before it starts to sweep to the left in order to get to the side entry garage that's on the west side of the dwelling.
That allowed you to minimize the total disturbance on the original construction of the dwelling that's there now.
Yes, a lot of the existing dwelling, for having the pages in front of you that you can see, there are some shaded lines behind the existing dwelling where you can see where the circular portion of the driveway was that is underneath the existing dwelling. So a lot of the impervious offset each other which was why we were trying not to be increasing the impervious by more with the placement of the new dwelling.
Thank you. That's all.
Have you decided yet?
No, I think, go ahead.
Yeah, you have no.
I think those comments are mostly for the planner, but,
Oh.
Okay.
yeah.
All right.
That's still warm.
Yeah, I just always like, as we all do, like to make sure all the reports are covered. I know there were environmental commission reports. I don't know if if the engineer was probably best suited as between the engineer and planner, but did the applicant have an opportunity to review the July 21 environmental commission report and the recommendations contained therein? And can you address those? Are there any recommendations made by the commission that you would stipulate to as conditions of approval should the board grant approval or not? And again, they're recommendations.
Sorry,
Board will
I'm just
ultimately
rereading
decide
it.
what are conditions. The board will ultimately decide what the conditions of approval, if there will be an approval, are.
Thank you.
So you're referring to the Environmental Commission report dated July 21st?
That's it.
And the first two bullet points deal with recitation of the facts related to the property. And those
I think the
figures,
recommendations start on the second page.
the recommendations, but on the first page, the third bullet indicates no wetlands or floodplains. Is that correct?
Yes.
The property is covered primarily in maintained grass with mature evergreen trees, no visible erosion. Is that correct?
Yes.
The plans, let's see.
I know, I don't have any issues with the recommendations. I mean, the recommendations speak to that all plants should comply with the do not plant list.
Correct.
And stormwater management, given the new house, they're expected, that all plants have a proposed seepage pits, and they're gonna go through the same lot grading permit that would get approved by the engineer as well.
You could, on behalf of the applicant, are you stipulating to those recommendations as conditions of approval should the board grant approval?
Yes.
Then there's general recommendations at the bottom of page 2.
Mhm.
Rooftop solar, lighting, dark sky compliance.
I don't know of any rooftop solar at this time for the lighting. It would comply with the dark sky. I mean, my understanding of any residential houses that I work with have, lights at the garage doors and the front doors. If they have some floodlights, that would be on timers in the back just for safety. Like, I mean, I have that at my house too, but it would comply with the dark sky. To my knowledge, there's no intention of solar panels, so if there was, they'd have to comply with the state.
That was it for the recommendations on the environmental commission. The fire department review had no questions or comments dated June 25th, and June 25th site inspection committee had no questions or comments. And I think the planner's reports will be addressed by the planner. I have nothing further, thanks.
Any more questions from the board? Mr. Simon, do you have any questions for this witness?
Ms. Osterkorn, good evening. So I have a bunch of questions, but let me start with sheet 2 of 3. Please pull it up. Thanks. So just so I understand, so I'm looking at the first note. And by the way, it's your understanding based on the deed that closing on this property took place about December 1st of 2023, correct?
I don't have the
Yeah, that was
date of that.
What's that?
I don't have the-
Bill just gave us the deed tonight, and that's what
Okay.
it looked like, that the deed was delivered on December 1st, 2023. Does
Okay.
that sound about right? If you know?
Sure. I don't know. I don't. I could.
Okay. And then it states here that a survey was done dated April 13th, 2024. So prior to closing, you were not contacted to create a survey of the property, correct?
Correct.
You're not aware of any other surveyor that was contacted to create a survey of the property, correct?
Correct.
And so when it states that survey by Omlin and Osterkorn, that's your company?
Yes.
Okay, dated April 13th, 2024. When were you originally contacted to create a survey that ultimately was dated April 13th of 2024?
I don't know the email date off the top of my head that I was contacted. It was prior to April 13th.
Do you have any recollection as we stand here tonight, approximately what month you were first contacted?
March.
March. So approximately 3 months, give or take, after 4 months after the closing, you were contacted and you were asked to create just a meets and bounds survey of the property?
Boundary and topographic survey.
Boundary and topographic survey.
Yes.
Okay. And that required you to go out and review the property and take some shots of the property to determine topography?
Yes.
And the survey that was submitted on sheet 2 of 3, that's not a survey dated April 13th, 2024, correct?
No.
Have you submitted to the board the survey that you created dated April 13th, 2024, and that you refer to on sheets 2 of 3?
I don't, Nancy, I don't know if that was actually, oh, sorry. The documentation that I provided to the attorney for submission was this 3-sheet set. I didn't give a separate document of my April 13th, 2024 survey.
Okay, so you've never provided to Ms. Lottenville or to the board the survey that you refer to in note 1 on sheet 2 of 3 dated April 13th, 2024, correct?
Correct.
Okay. And with regard to note number 3, dwelling construction pursuant to building permit number 25-0053. Were you retained to assist in preparing an application for a building permit for this property?
Yes.
And when were you first retained to work on an application for a building permit for this property?
It's the end of, well, we did the survey in March of 2024. I think it was the fall when we started the process for the plot plan, when I got architectural plans, and then the applicant came and said if I could satisfy the lot grading, because I'm trying to figure out when they submitted, because this permit was issued in 2025, it was earlier this year. But I didn't bring all my contracts with me, but I'm going off of memory now of, it was the end of last year when I got architectural plans for the job.
End of last year, the end of 2024?
Yeah.
And who did you receive architectural plans from? you recall the architect on the project?
No, but she won reference as the architect.
I'm sorry?
I think she won reference as the architect. I don't recall his name off the top of my head.
I don't see a reference to an architect, but I may have missed it. Can you check since these are your plans, if you don't mind?
It's blurry on the screen.
You want to look at mine? Here's
No. Do you have the hard copies? They might not have been on this plan. They were on the plot plan.
Mhm.
Yeah, thanks. No, these didn't refer to an architect. The plot plans that were subject to the building permit number referred to the architects. But I deal with a lot of architects on a daily basis, so I don't have the name off the top of my head.
And when you made the application or when you assisted in the application for the building permit, how did you participate in that project?
I was given a footprint of a house by the architect, and it was looked at from the zoning perspective of conversations of where they wanted to be placed and how we would change the driveway. And
you were part of that discussion?
yes.
Okay, and you reviewed the zoning ordinance at the time as part of that discussion?
Yes, we did an initial zoning chart for the lot.
Right. And then when you did the initial zoning chart for the lot and you did the analysis, did you also contemplate at the time the possible subdivision of this property?
I did not contemplate that.
Okay, so all the zoning information that you provided that led to the issuance of a building permit that you identify on sheet 2 of 3, you did not at any time contemplate what the zoning of the property would be for either of what's now proposed lot 6.01 and 6.02 should a subdivision take place?
No.
And looking at sheet 2 of, and by the way, how is it determined that the house that currently exists was sited in that location as opposed to any other location on the lot?
I was guided by the applicant and what he wanted.
And do you know why the applicant wanted the house to be to the, we'll call it the northwest or the west of where the existing house was?
The conversations we had were mainly about the impervious coverage of trying to, because we were considering the major development, and I had said, I don't want your increase to be. And when he talked about potentially a future pool and how it was being sited on the site of facing and the pool behind it, and we knew the pool needed to meet the rear yard setback requirement of 100 feet, it pulled the house forward more and it overlaid into the driveway, which then I said, oh, that's good because the impervious can offset each other. We originally had the house back a little bit further, but then when we had discussed a conceptual pool, I said, well, that's going to be a variance because it's over the rear yard setback line. So then we pulled the house forward more.
At the time that you're having these conversations, was it contemplated that the existing pool on the property would be removed?
Yes.
And when you were having those conversations with regard to impervious coverage, why were you worried about impervious coverage on this lot that's 4 acres and change
Because
for one house?
For the size of the drainage system that he'd have to put in for the seepage pits, it's based on your increase in coverage. So if you increase by more, he'd have to put multiple seepage pits in.
So you're talking about, you were concerned about an additional 1 acre of disturbance or quarter acre of additional impervious coverage?
No, it was just that the increase in coverage overall. So if he only increases coverage by 1,000 square feet, he only has to size the system for X amount. If we increase it by 2,000 or 3,000 by keeping and we're increasing it by more, the drainage system he has to put in for a single family home is larger, which would then not entail just collecting the house water. We would have to then try to collect driveway water and other things to offset just the balance of what that increase was. We were trying to keep it at the house roof area, so it balanced out.
And you have on your plan building coverage of, was it 3833 for lot 6.01 and 3400 for 6.02?
Yes.
And that's assuming, that's a ground floor, correct?
Yes.
So if these houses are two-story homes, is it fair to say that the square footage would approximately double from what that building coverage number is?
Well, the applicant's house is a one-story home, so it's not doubling. The conceptual plan of a 3,400 square foot home, yes, could be doubled.
Could
It's
be
two-story.
6,800 potentially as a
Potentially.
two-story.
Mhm.
Okay. And when you participated in the permits for the demo and you did some grading, was there any steep slope disturbance at that time?
Not that got brought up by the town with our permitting. We stayed within the disturbed area with the demo and kept everything in the general area that was already disturbed.
You mentioned during your testimony about the creation of this lot. Are you aware that this lot was created by subdivision?
The original
The
lot
mother
of 6.
lot, yes.
No.
Okay. Did you do any investigation as to the history of how this lot was approved or created for purposes of meets and bounds or otherwise?
No.
And when you participated in the so you first worked on the subdivision for this property after this home was being constructed? That was the first time a subdivision was discussed?
Yes.
And at the time, did you review the ordinance to determine the number of variances that would be required for such a subdivision application?
My initial review was just with the lot area and the lot width, and it was working with the attorney that we had found out the other variances with the setback, at the setback line, the 40 feet behind it. So the initial assessment was just an area variance, but I wasn't brought in as an initial planner to go deep dive the ordinance.
Have you since done a further deep dive of the ordinance to determine the number of variances required as reflected in your plans?
I have not.
So your zoning table on the third page that identifies a bunch of variances that didn't come from you, that came from someone else?
That was a team effort with all the professionals on the team.
And with regard to the existing features that remain, you agree that the existing pool that was since removed, that was formerly located at least partially on what's now lot 6.02, correct?
Yes.
And the property as originally constructed, if the subdivision were created with the original house remaining, that would result in a setback for that house, correct? Required setback based on where the subdivision line's located?
The variance for the house?
Yes.
Yes.
And you're on page 1 of 3. You don't show all the properties within 200 feet of this property, do you?
I know. I realized that when I was pulling out the tax maps, it doesn't have the ones across the street on it because I have them here with me now, but.
Right. And the ordinance requires you to show all structures within and homes in buildings, excuse me, within 200 feet of this property, and that has not been shown on these plans, correct?
Correct.
And you also show on your plans properties within 200 feet of not just lot 6, but also lot 5.
Yes.
See that? And,
Yep.
and why is that?
There's a drive, there's a driveway that runs along.
I'm sorry.
I'm sorry.
Can you show me on the plan which?
Sorry, on sheet
Why
one.
don't yeah, you want to show on sheet 1? Okay.
I can show sheet one. I mean, on the top of the zoning map, you can see a dashed line of a driveway that ends up coming through to lot 5 that's behind it.
You mean to the west of this lot?
Yes, to the west of the lot, and then it goes to the north of the lot.
Right.
So it was a conversation of wanting to be extra prudent and notifying just because of their access that comes next to us and behind the subject property, of including them in the notification to make sure we captured everything.
Does anyone with rights to that access have any rights relating to lot 6?
Not that I know of.
Does the owner of lot 6 have any rights vis-a-vis that access that you just identified on lot 5?
Not that I know of.
And your subdivision map doesn't show any of the survey markers located on the property, correct?
The property corners we found?
Yes.
Sheet 2 does.
They do?
If it got knocked off sheet 3, that was not intentional. Whoop. Sheet 2 shows the iron pipes we found to the southwest and southeast and the northwest corner. It just says, it's a circle that says IP.
So the IP, and did you put in those iron pipes?
No.
Do you know who put those iron pipes in?
No. I can check our file to see if they were capped with a name on it. When we show them as symbols on our plan, we just mark them with an IP. But I can check the point file to see if there was a cap with a name to it.
And the IPs, I'm looking at sheet 2 of 3, they're located to the north of these trees that you're proposing, correct?
Those are existing trees.
Existing trees. So they're located to the north of the existing trees, correct?
Yes.
So is it your position that those trees are nevertheless located on the subject property?
Under the current deed description, yes. After a right-of-way dedication, they will be in the right-of-way owned by Morris Township.
And if they're going to be owned in the right-of-way owned by Morris Township, is Morris Township going to be presumably maintaining those?
Depends on how the right-of-way dedication is worded.
You're not showing any properties, as questioned by Ms. Murphy, actually, across from Schoolhouse Lane, right? On any sheet that you've submitted, correct?
No.
And are there any utility or other easements that impact this property?
Not that we have from the title search I was provided.
Okay, and the title search that you were provided, that was provided by the owner of the property at the time you purchased the property?
No. We requested it after the last meeting where questions were brought up about the right-of-way line, that I had a deed search done
You had
By-
a deed search done?
by a title company, yes.
Okay, so the deed search just ran deeds from, was it a 120-year search?
No,
If it was not a 120-year search, how many years search did you run?
60.
So prior to presumably 1960, when you show the first deed, you don't know the history of the property before then, correct?
Not that I have in front of me.
And you're not aware of the road return on Schoolhouse Lane prior to 1960 either, correct? To determine the right-of-way in the county records?
The original deed had a reference to a map which had referred to it as the 66-foot right-of-way, and it talked of the road maps. And when this was brought up, that's why we did the deed search. And then it showed some of the history on some of the other neighboring properties that we did searches on to justify and support that it is a 50-foot right-of-way, which is what the tax maps have on record. A couple lots down, we had found a right-of-way dedication that was done for 25 feet, which supports a 50-foot right-of-way, not a 66-foot right-of-way.
And you know those right-of-way dedications were correctly done? Especially when the deed book showed that it's actually a 66-foot right-of-way? And you didn't search prior to 1960? Okay. You don't show any water courses within 200 feet of this property, correct?
Correct.
And this property is located in the RA 130 zone, correct?
Yes.
And there's property surrounding it located in the OSGU zone?
To the east.
To the east. What about to the north? Did you do any, because you haven't provided a property or a zoning area map, are you aware to the extent to which the properties in the surrounding area, whether it's 200 feet or 500 feet from this property, are located in the RA 130 or the OSGU zone?
I believe this fell under the criteria of the planner that has exhibits to show with their testimony about the surrounding neighborhood.
Okay. So was there anything, and I apologize for not asking this before, the plot plan that you submitted to the town, there is no reference on there to any aspect of this subdivision plan?
No.
And on sheets 2 and on sheet 3, you show to the north and to the east all these squiggly lines, but you haven't shown any type of evaluation of number of trees, type of trees, canopies, drip lines, etc., correct?
The trees that we located on the property are noted with the tree symbols. The squiggly line is the tree line that we located around the property.
So when you look at the tree line on the property, how many trees are we talking about and where are they located?
I don't have that information. It was not required.
It wasn't required as part of what? As part of the subdivision application?
When we had our review letters and had our TCC meeting, it wasn't asked to locate all trees on property lines.
So the trees that are within the area that you're identifying on sheet 3 of 3 to be located within the dedicated area that's going to be dedicated to the township,
Mm-hmm.
right?
Yes, sorry.
And what kind of trees are located there that you're depicting?
Evergreens?
And how tall are they?
I don't know.
Okay, have you done a survey of them in terms of drip line, canopy, root system?
No, we located the center of the tree, and it was shown as a symbol.
Do you have any idea when they were planted?
No.
And just to be clear, on sheet 3 of 3, lot 6.02, your two-story dwelling is conceptual, correct?
Yes.
Your disposal field is conceptual, correct?
Yes.
Your grading is conceptual, correct?
Yes.
The front walk is conceptual, correct?
Yes.
And the driveway is conceptual, correct?
Yes.
You show seepage pits or dry wells to the east of the lot, or, I'm sorry, of the dwelling, correct?
Yes.
Okay. And have you done any testing related to those test pits? I'm sorry, to those dry wells?
Not those specific ones.
Have you done testing with regard to the dry wells that are located on lot 6.01?
Yes.
And what kind of testing did you do?
The testing was done for both the septic and the drainage to get depth to groundwater and percolation rates. So we know that the systems both work.
And those were submitted to the township?
Yes.
And the topography of the site has changed since April 13th, 2024, correct?
Yes.
And the topography has changed even since May 1st of 2025, correct?
Yes.
Have you shown or you provided, any plans that identify the current disturbance or topography of the site?
No.
Other than the 8 variances that have been identified to date, are you aware of any other variances based on your review of the ordinance?
Not to my knowledge.
And you haven't provided information to the board or any type of analysis to the topography of surrounding properties within 200 feet of the site, correct?
No.
And you haven't submitted stormwater calculations or drainage calculations for either lot 6.01, 6.02, or the cumulative lot, correct?
6.01 was submitted as part of the building permit.
I'm saying, but has 6.01, has that drainage information been provided to this board?
No.
And no drainage information has been provided for 6.02, correct?
No.
And no soil testing has been done in 6.02, correct?
Correct.
Just give me a minute. So is it, I was just, want to get clarification. Is it your testimony that you don't believe that cumulatively between lot 6.01 and 6.02, there will not be greater than 1 acre of total cumulative disturbance?
I believe so, but I don't have the exact numbers to tell you a number.
And you also believe that cumulatively between 6.01 and 6.02, there won't be more than a quarter acre of an increase in impervious coverage.
Yes.
Okay, I have nothing further at this time. Thank you.
Thank you. Your questions from, or any questions from the public for this witness? Again, name and address, please, just for the record.
Richard Smith, 44 Schoolhouse, right across the street. Ms. Oscorn, the initial survey was done with, did you say that the initial survey was done with the deed that was given to you? No other data was acquired?
At the time, my contract was to be provided by the homeowner a deed that I did the survey off of.
And you did a survey with one deed?
At the time, yes.
Where you didn't have concern for any issues that might be involved with the surrounding properties?
No.
Is that how you do all your surveys?
No.
Okay. The right-of-way for this road was created in the late 1700s as a 66-foot road. I've read it. Does that not concern you that you should have your hands on the actual documents that create the right-of-way?
Going forward, we did, and we tried to do the best due diligence of research we had into both those right-of-way maps and the others.
Yeah.
The only then questions I have of if it was a 66 right-of-way of the impact to both sides of the street, not just ours. And the other documentation we had found supported the 50-foot, understanding there was a history of a 66, but there was only the one map that I read recently, but we had other documentation that supported the 50-foot right-of-way.
Okay, so when you found the additional deeds in the neighborhood that claimed a 50-foot right-of-way, do you understand that a right-of-way that was created at 66 feet, would you say that if somebody files a deed or dedicates 25 feet of right-of-way, that changes the 66 road to 50 foot?
No, I'm trying to, that if it was 66 feet, but then,
If it's a 66-foot road and somebody calls it 50 feet in the deed, does that make it 50 feet?
no.
So it would always be 66 feet, right?
To that point, but other evidence we found on the block and other deeds and right-of-way dedications supported a 50-foot. Is the reason I should not.
All right, I just don't understand. Can you explain to me how you can ignore a 66-foot road return?
I believe you asked that and she answered it. They looked at
She
the
didn't
number.
know it, she thinks that, okay, all right.
No, she said they
So,
looked and other evidence
the other
supported the
thing-
50 foot.
A few other things. On your map, you show the dedication of like 25 feet. Is that from the deed line that ran into the road somewhere?
That's
That's just 25 feet over from the
from
deed
we
line?
had the deed called to the center line of road, and then based
Okay.
on the evidence we found of where it lined up exactly with where 25-foot, understanding that the neighbors both to the south and the north, or the west and the east, had a dedication done. And we had located the properties to the southwest that there was a deed dedication that was done as a 25-foot right-of-way.
All right, so the 25-foot dedication eliminated the 66-foot right-of-way. Is that what you're saying?
That was my analysis.
I get it. Now, when you prepare the map, you don't show the center of the road, you don't show the pavement, and you don't show the right-of-way on the other side of the road. Yet, are you familiar with the New Jersey Administrative Code that governs surveys?
Yes.
Okay, are you aware that those are required in that?
Yes.
Okay, but you didn't show them.
My published survey showed it, that the referenced one.
Okay, now are you also aware that if you reference a survey on a drawing, a separate drawing, a signed and sealed copy of that survey must be submitted to this board with the application? That's in the administrative code.
Okay.
Right, but you didn't do that.
I didn't do the submission.
Well, but the regulations in the administrative code
Okay.
govern the practice of engineering and surveying, not lawyers.
Okay.
So it tells me that that's a requirement that you have to make sure is done. If the lawyer wants it down here, that's pretty okay, but you have to make sure it goes.
Okay.
So now, if I knew where the right-of-way, if I knew where the pavement was, I could tell you where the right-of-way is. Because it's 33 feet or 25 feet or whatever you say from the center of that road. The physical center of it. We're talking about a road that was established
Sir?
200 years ago?
Do you have a question?
Oh, yeah. Yeah, I do. Sorry. Jeopardy. So I don't know how far that right-of-way line that you're showing here is actually from the center of the road. Can you tell me how far it is from the center of the pavement?
I can measure. The only other comment I would end up having back to that is that sometimes roads aren't actually centered in right-of-ways. My street that I live in, the road is off-centered. It's not actually where
But when you're
the
talking
center
about
pavement is.
when you're talking about an ancient road, aren't you bound to use the center line of the road unless you have firm evidence to go elsewhere?
Sure. Go. The pavement to pavement is 20 feet, and I show where the property line is at 9 feet
From where?
from the curb. So it's a foot off center based on, I made the decision based on all of the iron pipes and stuff we found along the block.
Okay. And what are you looking at there that shows the actual other side of the pavement? What map are you looking at when you're scaling the central line off?
My lot, sheet 2 and 3.
Where's the other side of the right of way? Or where's the other side of the pavement on that sheet? Can you show me?
There's the 2 concrete curbs. I just took a measurement right here. I'm sorry. On the northeast side of the property between the curb lines.
Southeast side?
No, I went over to the northeast, the east, where it says concrete curb. Yes.
Those evergreen trees in the front, are they actually located or did somebody just like stamp?
No, we
Actually
located.
located the trunks
We
of them all?
located.
Okay. Are you familiar with the Recordation Act?
Say it again?
The recordation.
Recordation Act, the recording law that governs the practice of surveying and preparation of subdivisions?
Not off the top of my head. I had to know it in order to get my license, and I took an exam, but I don't read it on a daily basis.
How long have you been licensed?
Since 2011.
Okay, this law passed in 2012. So there's a lot of requirements on that, in that document that you haven't met. Do you intend to meet them before you complete this project? Like the monumentation, actual road monuments have to be set on this property?
Yes.
Okay. And that you're aware that what you should be, you're going to need to read it because it's required to be on this map before it's submitted to this town. Okay. I think if a map came back that met the qualifications of the acts and the code, then it would be much easier to analyze your submission. I don't speak to the merits of a
Sir.
2-acre
That's,
subdivision.
you're dribbling into comment now. We can do
Okay.
that at the end.
Yeah,
If you
so
have any more questions, that's
I'm
fine,
just
but
looking,
if you want
I'd
to
just
say,
like to see a complete application so it can be reviewed by the neighbors that are concerned. Thank you.
thank you.
Uh,
Ms. Luddenville, do you want
Mr.
to
Chairman,
respond to any of these?
If I may, I'd have one quick redirect question
Yes,
to the
please.
witness.
Before, did we confirm there are no other members of the public?
Oh, I'm sorry.
Oh, I'm sorry. There are other members, yes, yeah, other members of the public. And then, okay, since we've passed the 9:30 time now, I want to
We're
complete
closing to members of the public asking questions.
asking
of this
questions, and we'll complete, I hope we'll complete with this witness, and then we'll,
witness. Redirect from.
redirect, but that we'll go through whatever we have to with this witness to
Thank you.
finish.
Very quick, Mr. Chairman, if the exhibit for,
I can't hear you.
if the exhibit for tax map and historic could be brought up, please? The third one.
Sheet 3 of Exhibit A1?
No,
New
tax map.
exhibit, tax map.
Oh, I'm sorry. New exhibit.
And so this would be, are we at exhibit 2? A2.
2, okay.
2 sheets of the tax map, either sheets 35 and 36. Is there any reference to the width of the right-of-way on the tax map of Schoolhouse Lane?
It's noted as 50 foot.
And who prepared the tax map?
Richard Smith.
Thank you.
Is that it for your questions? That's it? Very good. Anything, I guess, board, any other questions before we wrap things up here to the board?
My question's for the planner.
Okay, then I think we will,
Mr. Chairman, I guess we'll need a date certain
Yes.
from which we can
yes,
carry
we need
this
to
matter.
carry this matter. So
I'm
we-
going to guess the time and location, but I'm not going to guess the date.
Yes. Do we have a possible date?
November 17th?
November 17th?
November
We don't
7th.
have an early November meeting, correct?
They're correct. We don't have any earlier.
It's the Monday of that week.
The
yes.
Monday
night.
Yeah.
Well, some people start early.
Yeah.
Some people go Monday night.
More incentive to finish up.
Like an optimist.
It worked for me.
Is that acceptable?
And your planner, your planners.
Yes, Mr. Simon?
Saying November 17th. I'm an attorney in the municipality that night. Ms. Holmquist is our professional planner. She has a conflict on.
Well, first, let's start.
What-
My recommendation, Mr. Chairman, is at least let's start with the applicant, see if they can make it, and then we'll go from there.
Okay,
We're available.
they are available. And said that they're not.
And,
I mean,
Ms. Holmquist, if I understand correctly, is a sole proprietor, so to speak, of her planning consultancy.
right.
Mhm.
What I normally recommend in these circumstances or request of the board, so not to completely hold up the applicant, is if the applicant.
Simon, can you please use the microphone?
Right.
Bad habit. What I normally would request on behalf of my clients is the following, that not to hold up the applicant, that on the November 17th date. I don't know if the board has other matters, but that the applicant can continue and present, I'm assuming, Mr. Doherty, their professional planner, and have him do direct, answer questions from the board, answer questions from the board professionals, other members of the public, and then we would come back at a future meeting so that I would have an opportunity to cross-examine Mr. Doherty and then present Ms. Holmquist.
I would not be in favor of that. That drags it out yet another meeting. And it gives a lot of advantage with the transcript in hand to develop cross-examination. I think it's inherently unfair. In addition to which, I am not aware, I would have to bring my planner back a second time in order to redirect.
Yeah, I would agree with that. I think if we're going to continue, if we can't do it on the 17th, what was the next available day? If we would have to continue to another date anyways,
Okay, next available date would be December 1st.
would that be acceptable?
Yes.
My planner and I are both available on December 1st.
Okay, let's make it for December 1st. Yeah.
Thank you.
Just, if I may, Mr. Chairman, because only
Yes.
because you know I like to do it.
7 o'clock here.
That's right. You stole my thunder again. No, yeah, but we are carrying this matter without further notice. So this is the only notice for members of the public. Carrying it to Monday, December 1st, 2025 at 7 p.m. at the same location.
Thank you.
Thank you.
What? Yes. Yeah.
She was putting it back in the thing
Yeah.
over
Oh,
there.
oh.
That's what it was.
Yeah, so if people are going to leave at this point, we have other business. You're certainly welcome to leave, but please do so quietly so we can continue. Thank you. So the next thing on our agenda is another public hearing. Please be quiet. Can we, if you want to continue talking, you can talk in the hallway. Thank you. Another public hearing on I'm not supposed to call it a courtesy hearing, but could you on PB 1225, Township of Morris, could you introduce it, Sonia?
Yes, Mr. Chairman. Our next application is PB 12-25, Township of Morris for courtesy review, block 8003, lot 15, 50 Woodland Avenue in the OSGU zone. Applicant proposes the installation of a temporary 8x16 storage container.
Mr. Warner?
Yes, Mr. Chairman, this is a capital project review for the benefit of the board and members of the public. We have had these in the past, but it's been some time. A capital project review referral under section 31A of the municipal land use law, whenever the planning board shall have adopted any portion of the master plan, which we certainly have, the governing body or any other public agency, here it's the governing body of the township, having jurisdiction over the subject matter before taking action necessitating the expenditure of public funds incidental to the location, character, or extent of a project, shall refer the action involving such specific project to the planning board for review, the capital project, for our review and our recommendation in conjunction with the master plan. And such body, the governing body, shall not act until 45 days have elapsed after such reference without receiving the planning board's recommendation. So we review this capital project on behalf of the township. We, as the planning board, the project is being presented by the township engineer. What's that?
For optics, I would.
For optics is over there. That's appreciated. And again, our role is to review it in conjunction with the master plan. A consistency recommendation or finding is appropriate. And also, we can make recommendations, but only recommendations. We cannot deny the application. This is not a land development application. We cannot impose conditions on the township, but we can make recommendations to the extent we feel those recommendations would bring, assuming you find the project to be consistent with the master plan, there may be recommendations that you make that are designed to bring the project even more consistent with the master plan, in your opinion. So that's essentially the role. It's a recommendatory role, yet notice is not required. However, notice was provided because that's how we roll in Morris Township, if you will. It is a public hearing pursuant to Section 10A of the Municipal Land Use Law, so we'll have those formalities. So I did have an opportunity to review the notice, notwithstanding that it was not required. It happened to be sufficient in content and happened to be timely served and published. It was served by certified mail on October 6th, published on October 9th, both at least 10 days prior to this evening. And I can swear in our board planner, and I can swear in the township engineer who will be acting as the capital project engineer. So if you
Mr. Warner, before you get going, I'd just like to.
Oh, I'm sorry. Yes, thank you.
Mr. Chairman, I'm going to recuse myself from this, this particular subject because I live within the 200 feet of this project, and it's not fair for me to sit on here on the dais to be part of it.
Thank you, Committeeman.
Thank you. Thank you, Mr.
Yes,
Ravitz.
we did address that while notice is not required, one benefit of many of the notice was that we were able to confirm that one of our planning board members is within 200 feet, so out of an abundance of caution. Appreciate that.
Thank you.
If I could swear in our township engineer and our board planner, if you'll both raise your right hand, do both of you swear to God or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you both. I believe we can now proceed with our public hearing on the capital project review, Mr. Chairman.
Okay. You may proceed.
Thank you.
I guess we'll accept your qualifications.
I think
Subject
that's
to you.
prudent to put on the record. Thank you, Mr. Chairman.
Can we have the plan up, please?
Yes, Joe.
Thank you.
And then on that plan, if you could zoom into pretty much dead center on the plan and a little bit to the plan right.
Zoom way in.
Yeah, well, so we're going to zoom in so we could see, the courtroom that we're sitting in, and then to our rear.
And just for the record, this is
This is-
dated
this-
September 24th, 2025. It's the proposed storage pod. plan.
Correct.
Thank you.
So the plan in front of you was prepared by our Township Engineering Department under my supervision. The project, the capital improvement that we're here to discuss is to locate a pod container to the rear of our existing structure on what I'll call the easterly portion of our property, nearest our existing generator, just outside of these doors here, to an area that is convenient to existing points of egress from the construction code department for records management. We're in the process as a municipality of addressing records management in physical hard copies that are being transferred into digital storage, and going through that physical hard copy storage running out of room at this current time. So as the construction department is in the process of doing that digital recordation and consuming more paper and more space while we're in the interim of looking at additional renovations to the building to accommodate the growth of the construction department. We have an immediate need for what we'll call semi-permanent storage installation of a pod. This is, I call it semi-permanent in that it is not a short-term temporary fix. It is more of a longer term that we would anticipate being over a year of having this on the site. We chose the location, one, because of its proximity to the engineering and construction offices immediately adjacent through existing points of egress to the building, so ease of access for people to step in and out of the building and get in and out of that storage even during inclement weather. And also because of its location next to existing emergency management infrastructure such as the generator that already provides existing screening in that area as shown on the plan. You see there with a U shape of landscaping that is mature and existing around the generator, providing screening for any view sheds from the south with the opportunity to then supplement with additional plantings to the east and then the north side of the pod as necessary. There is existing mature trees on the eastern side of the property that's adjacent to our lot line, what is the rear lots of residentials to the side of our municipal complex. And that provides some existing screening. And to the extent at ground level, there is some existing vegetation of shrubs and other things along that common property line that provides some ground level plantings. So while we didn't feel it was critical to proposing the screening at this time, we thought in the interest of concerns for neighbors that we would anticipate extending this existing screening line north, consistent with the line that's there now, to provide that direct screening to specifically tax lots 17, 16, 17, and 18 from a potential view shed impact. The pod company has made a site visit to be able to look at the location and orientation. This is the desired orientation, but because of overhead lines that come essentially directly over north to south over the existing generator, there is concern over bringing in the pod and dropping it in that exact location. So we do anticipate it may orient slightly closer to our building rather than further from our building, and may orient north-south as opposed to currently east-west to avoid that overhead conflict. And I'll field questions.
Mr. Chairman.
Yes. Yeah, Ms. Murphy.
So,
Your microphone's not
you
on.
commented on the fact that there was easy access. I don't see easy access to the pod. It's on the side of the building. You either have to walk around through the parking lot or walk up the front.
So through
It's right here. Is there a
through the
door?
rear corner, essentially
I'm not seeing a door.
the southerly corner of the building, there is existing egress through the back of the construction office.
There is a door there?
There is, yes.
There's a door.
So the staff can, from their desk in the construction code department, which is the southerly corner of our existing structure towards Woodland
I
Avenue.
don't see it.
No, it's not shown on here.
It's not on there.
Where
Doesn't
is it?
show the
Can
point of
you show
view.
me?
So it's going to be existing egress in this area is right around here.
So
the
I see a hatched building
building
wall,
edge,
but
yes.
no door. It identifies.
It's not illustrated on here. It is, so our interior hallways aligning through here with engineering on this half of the building, right? And then our conference rooms and our courtroom, and then.
Okay, so my only point is if we need easy access if you're taking documents in and out. So if there's a door there, that's great.
Yeah.
I don't see it on the plan.
Yeah, so it's from this rear corner, right? roughly right here along the edge of this landscaping.
Okay.
Egress
It's
from,
not shown.
yes, so it's not.
The other thing I would say is because of inclement weather, hopefully this is mounted on a pad and it has some kind of solid walkway, so people aren't stumbling across grass and mud to get documents in and out.
We have existing access on the side of the building, and then in this area is lawn. So we
But
can
that's grass,
use
isn't
that
it?
area. We can,
This is sidewalk.
there's
Is this-
a
okay, so
sidewalk
that's not on the
immediately
plan
adjacent
either?
to the building.
Okay, all right, so you
which
have a
is part of-
sidewalk and a
yeah,
door,
which is
not
part
on
of
the
the
plan.
emergency access egress from the building, so that's where that emergency point of access is. It's commonly used by staff to take a break outside, get a break
Okay.
for there. come
Those
back
are my
into the
only two
office.
concerns, to make it easy to get to and from, and to make sure that people don't get mud all over their shoes trying to put
Right.
documents in the
So
file.
the distance that we've set it at was essentially our minimum, because we wanted to ensure that from the frontage on Woodland, it was fully screened by the existing
Right.
improvements. So we're talking about basically traversing the width of this area of the existing generator pad and AC unit pad to go from that point of egress over to that area.
You know, you have already addressed the potential of future screening, so those are my only two questions.
Yes. Any others?
Any other questions? Comments? Yeah, I would just, encourage, if it is semi-temporary and if you're looking at something like a year additional screening would be nice. If
Yes,
it was shorter
absolutely.
than that, that's, but going into the spring would be, okay. That would be my only suggestion. Anything else? Then
Let's go.
I'll support a motion. Oh, wait a minute.
It's a courtesy.
Oh, technically it's a public hearing. Are there any questions from the public? Yeah, please. Yeah, state your name and I'm sorry.
Chris Pizzo, 63 Old Glen Road. My property abuts to the municipal building. When we received the notice, it said it was temporary. It wasn't clear on what temporary meant.
You know what, if you don't mind, I'm gonna swear you in. This way you can ask questions, make comments, whatever you like all at once. So please raise your right hand. Do you swear to God or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. And Chris, okay, we have your name and address. Please proceed. Questions, comments, votes.
Yeah, so it wasn't clear what temporary meant. You guys are saying it's a year. Hopefully it's a year. It's not 5. But our initial concern was obviously just looking out the back window or sitting on the deck and seeing this thing. Doesn't sound like we have much of a choice. It's coming. But having some type of screen, I guess, is necessary.
Appreciate it. So what we will be offering is to extend this section of landscaping, same type of species, further north, and then hewing that back towards the building so that from angles as you go out towards our parking lot and additional properties to the north and northeast, also provide that same benefit. So similar to how we're screened on the 3 sides here with the existing infrastructure, we would do the same for the pods.
Do you have any idea what color this thing is?
Most commonly, they are white. They're fresh painted white. They may have a label of the company on the side of them. But any branding would not be visible to the nation properties based on the proposed landscaping.
Is it going to be a fence and shrubs? I think that's what you have right now at the around the generator, right?
We would intend on installing shrubs only, close enough to not have gaps in them for view shed. And then that would give us the opportunity, once they're removed, to then relocate those throughout the property without having hard infrastructure to also remove.
Okay. Have you guys thought about having documents exposed to the weather? in this thing? I mean, it's like sealed, so it's not gonna get wet, but you're gonna have moisture and whatnot. You're gonna probably have like mildew problems. I think that's your problem,
So
not ours, but.
It is a concern. We are considering using it for a shorter term storage of each document so that the documents can be pulled from file, making space for the current documents, and the documents about to go to archive can go there, be prepped, and then taken to archive to go through that process, which is currently does have budget allocations for archiving materials. And so as we archive and they come back, they don't then have to go back into storage.
So do you realistically think this thing's only there for potentially a year, though?
It's going to be over a year. It'll probably be in the, I'd say, 1 to 2 year term. And at the same time, that's giving us the flexibility to look at the expansion of construction department into adjacent areas where some of the office space is underutilized, to expand that area and create more storage internal to get out of that storage unit as fast as possible.
And whatever shrubs you plant will be mature enough to cover this thing? We're not waiting 2 years for them to grow in?
Correct. Provide ample height to cover the structure.
Okay. All right. Thank you.
Thank you.
When will the pod be installed or delivered? What month of the year?
I believe they're prepared to deliver it as soon as
Okay,
we
so
have
before the end
approvals.
of the year, maybe?
Yes.
That means screening is gonna wait until they can plant.
Well, or we'll,
As long as
or
you
we'll
can
look
get a
at,
shovel in the ground, you can plant according to the nursery.
Yeah. Especially with, yeah.
So, I mean, if it's really coming now, it'd be nice to not look at it all winter, to be honest.
and we'll look to put some landscaping in immediately prior to its arrival.
We would appreciate that.
Thank you.
Thank you.
Thank you.
Okay. Question?
Thank you.
Okay, thank you.
Thank you.
Thank you. Okay.
I think we're closing the public hearing.
Yes, we're closing the public hearing. It's the public
I think the
left.
public is left, yes. So again, it's recommendatory. Maybe we should hear very briefly from our planner with respect to master plan consistency. And as I take the microphone away from
Yeah, I'll be very quick. I mean, our master plan doesn't discuss this type of thing specifically, but I think there is language in there about an attractive streetscape, et cetera, and I think the addition of the landscaping to shield it would certainly fall within that category.
So
It's
to your
not
opinion, it is not
It's
inconsistent
not-
with the master
not
plan.
whatever it is, the double negative, not
That's right.
inconsistent.
That's right.
Right.
Steve is infected.
and a recommendation by the board, should the board so desire to make that recommendation with respect to landscaping as was testified to by the engineer, if anything would make the project, in your opinion, even more consistent with the master plan?
Yes, it would.
Thanks.
Yes. Yeah.
Even less inconsistent.
Yeah.
Even less inconsistent.
Less
Less nodding? No, no. It's the hour.
Yeah.
It's the hour.
Yeah.
Yep, that's it.
Nothing further.
Okay.
Well,
Yes.
Now,
Yeah, then I will entertain a motion.
To adjourn?
No.
No,
No, we have more.
No, we need
Unfortunately,
the
we have more.
motion.
A motion to approve or recommend
I'll
that.
assume it's a motion to approve, finds it not inconsistent with the master plan, and make the landscaping recommendation.
That's right.
I move that we approve that it is not inconsistent with the master plan. That our review has,
And to make the recommendation on
and
the
I
landscaping.
recommend that we landscape so that the neighbors don't have to look at it.
Agreed.
So second,
Second.
I guess we have to call the roll.
We do.
Mr. Barrett,
Aye.
Ms. Van Order.
Yes.
Mr. Flowers,
Yes.
Ms. Murphy.
Yes.
Mr. Benoit,
Yes.
Mr. Quillen,
Yes.
Ms. Pariglia,
Yes.
Ms. White.
Yes.
So moved.
Oh, okay.
Okay, Bud, you're getting a big pie. Face it.
Okay, you're back.
Oh, yeah, actually,
Where
we have
is
a
my
little bit
agenda?
more business. Executive session.
Is there a calendar next? No, we have the,
It's actually in your driveway.
not yet, right?
No, we still have a little.
We still have a couple other things. We have, what did I do with my
We're gonna put a crosswalk there
agenda?
for them.
Sit up top there.
Oh, thanks. Well, the legislative committee, any reports?
No.
No, okay. Then we have the resolution to appoint our telecommunications consultant. You want to tee that up, Mr. Warner?
Well, we have a resolution designating our telecommunications. Mr. Peter Lupo, I believe we have a couple of telecommunication applications that may or may not come before this board because they may be administratively handled. He will be part and parcel of making that determination. If I recall correctly, one is the water tower at the Red Bulls facility, and one, I believe, is a municipal location as well. So I suspect there's a need for his appointment.
This is like potential cell phone towers or like.
I think they're, but geez. No, the attachments, oh my goodness. What do you call it? Well, no, yeah, there's a better name, there's a more legal term, but that's okay.
Okay.
They're
It's not a new tower, it's just.
not new towers.
Additional.
But something that we may need the consultant for. Oh, God. Yeah, okay. Okay. Yeah.
The code was the part I couldn't
Nothing to
remember.
do with the infrastructure, it has everything to do with the other existing tenants.
Exactly.
Right, okay.
On something else.
Okay, so we want to authorize the award for a telecommunications consultant.
It is
Okay.
a resolution, so motion, second, roll call vote.
Right, so can I have a motion to accept?
I move that we accept the resolution.
Second.
All in favor? There's a
Aye.
roll.
Aye.
Roll call. Roll call.
It is a roll call, a resolution, okay, right, it's not an appointment.
I'm not gonna get too many.
Roll call, yes.
Mr. Barrett?
Yes.
Ms. Van Orn?
Yes.
Mr. Flowers?
Yes.
Mr. Rabbit?
Yes.
Ms. Murphy?
Yes.
Mr. Benoit?
Yes.
Mr. Quillen?
Yes.
Mr. Revia?
Yes.
Mr. Bryan?
Yes,
So moved.
okay. Calendar review.
Oh, yes.
We have the, yes, we do want to look at that.
I have put the calendar together for 2026. The only one that I checked all the holidays, and the only one that I have to question for the board is September the 14th, or the 21st. Yom Kippur is the 21st of September. If you want to hold the meeting, that's the third Wednesday in September of 2026.
Well,
That's
that
not a
can't
good-
be, that's the
that's not a good
township
idea.
committee
No,
meeting.
no,
That, but the third Wednesday is the township committee
Monday?
meeting.
Yeah.
Third Monday?
Third Wednesday or
I'm
third
sorry.
Monday?
Oh, you said
I'm sorry, I
Wednesday.
said Wednesday.
Yeah, no.
Sorry, Monday.
Yeah, Yom Kippur is not a good idea to have
No.
a meeting.
no.
Yom Kippur is that Monday.
So it's that 21st.
And then that Monday, the 7th, is a holiday. So we can't have that Monday because it's Labor Day.
Oh,
Yeah.
well, it's a
So
late
what you're
labor.
saying is both the 7th and the 21st, which would be our ordinary TWAP. So you're proposing the second Monday and the,
Just the second.
Just the second.
Just one,
Just
just
one.
one.
Yeah, right.
Yeah.
So the 14th.
That would go, that's my preference.
Yeah.
Yeah.
Yeah, that'd be fine.
Right.
Yeah.
14th.
The 14th.
14th, yes.
Yeah, I don't think it's a good idea to hold a meeting on a religious holiday.
No,
Yeah,
no,
thanks for catching.
definitely not.
I can represent that Yom Kippur is the holiest of our holy days.
Okay.
So we'll have, just for that
We held that
month,
meeting
we'll have that.
Just another,
14th.
just the 14th, right.
Any other questions regarding the calendar for 2026 and January 2027?
That's okay.
No?
Okay.
Okay,
I'll bring it back in January.
okay. Thank you.
Will you or somebody else? will?
Well,
Somebody
no, thank you.
else?
Yeah, that's good news.
You just said it, Sonia. You just said it.
We're going to hold you to that now.
You know what I mean.
Someone else will bring it back.
You're right, Zach.
Someone else will bring it back.
Okay, we would have open for public comments, but the public have left. So we do have need for a closed session, right?
Very brief,
Very brief closed session.
as soon as the door is shut.
We can shut the door and
Already doing
stop
it.
recording. Is that the? Okay, now
I'd like to
let's
Make a motion that we close the meeting. Adjourn.
adjourn the meeting.
I second that.
All in favor?
Aye.
Thank you. Meeting
Thank you.
is closed. Thank you very much.